The motion was in regards to this working group that we were talking about to try and develop some form of guidelines as we looked at new tasks that were upcoming. And Councilor Hepler pointed out that people have the opportunity in the public to petition the government at any point regarding something that they would like, whether it be a task or anything else. And while this committee or working group would potentially help provide some guidance to that discussion within the MDC or the Vet Med Board, it may be an unnecessary level of bureaucracy, and that we can certainly allow the public to have the access that they deserve, and we can just tackle those particular tasks one by one.
So we do need to reconsider the motion. So the thought being that maybe we will form a working group, but that it will be a public meeting at the MDC and will be noticed, will involve the stakeholders, and we certainly can address these 7 items that have been put forward. Discussion, Dr. Sullivan.
Well, I think we need a motion to rescind, right?
Right, so since everybody voted aye, anybody can make the motion. Since the prevailing side has to make the motion to reconsider. Okay, I'm sorry. So anyone who voted aye can make the motion to reconsider, and then we will call the roll after anybody has a public comment on the motion to reconsider. Once we reconsider it, then the motion is laid bare before the board and can do whatever it sees fit at that, whatever it sees fit at that point.
Dr. Sullivan?
I move to reconsider the said motion.
Oh, is the second?
Second.
Jennifer seconds. Discussion? Any comments from the public? Call for the vote.
Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Dr. Nunez.
No.
Dr. Nolan.
Yes.
Jennifer Laredo. Yes. Kathy Bowler.
Yes.
Lee Heller. Judy Mancuso.
Yes. Yes.
Okay. Getting to item number 8 on our MDC agenda, the discussion and consideration of recommendations from the State Humane Association of California, called SHAC elsewhere in this document, the CVMA regarding public and private shelters and minimum standards and protocols. This is a huge undertaking, as we discussed at the last meeting, potentially having a separate section of the Practice Act that's dedicated to shelter medicine. And there are some things here, veterinary care on intake, rabies vaccines, and controlled substances, which are simply a small part of the list of things that need to be considered. They are not here for us to discuss at this point, just to kind of give you a serving suggestion of some of the many different facets of the discussion that we need to be having. And so we have, this started as a conversation about written orders. We also have a premise component to this, and then we have some issues where statute and regulation need to be updated or upgraded as well. Lots and lots of pieces to this puzzle. And SHAC and other humane agencies provided significant testimony at our last meeting. What we have asked, Erica Hughes was present yesterday and at the meeting previously, and gave us a nice set of guidelines or ideas about things that are kind of on the wish list, if you will, where problems are. And what the MDC recommended was that SHAC form a working group, since really they understand the shelter community, they are the shelter community better than we do, to look at the various issues surrounding shelter medicine, levels of supervision, discussions of sedation and anesthesia, which we will touch on a little bit later, written orders, etc., and that they then bring back a proposal to us so that we can start to work through it from that framework. So this is really more of FYI. This is how we're going to tackle that at this stage.
Judy.
So I'd like to thank all the participants, SHAG, CVMA, everyone to me, it's very important. And so I'm so glad to see everybody working on this. So we don't need to vote, this is just informational, right, Cheryl?
Yes.
I mean, Dr. Morris, okay, thank you.
Before we move on to the next item, we did rescind that previous motion on the holding the public hearing at the MDC. Probably need to call for a motion to accept that that's the path that the president communicated. So we rescinded the other motion, but we didn't move to the new plan.
Okay.
Understand the motion.
So is not the new plan the old plan? I mean, I think that the MDC's already been tasked with looking at these. So I feel that what I've heard is, no, we're not going to take that detour. The MDC is going to look at these, this list.
I think the new plan, which is substantially similar to the new plan, was if you, everybody can refer to the MDC advisory committee report, the first page, the red language. I think the only slight amendment is the MDC recommends that the BMB will essentially hold a hearing within an MDAC, with an MDC, sorry, an MDC meeting on these tasks and who can perform that. I think so. It's relatively the same thing, except the meeting, you're not really going to have a working group. What you're going to have is a part of the MDC's meeting that will be agendized and dedicated to tackling this subject. I think that's kind of where we left it. Is that correct?
And so you would recommend that there's a motion that states that is to that
Yes.
effect?
Yes.
Okay.
Dr. Sullivan.
But if it's a public meeting, an MDC, and it's agendized, stakeholders can come. So I guess I don't understand the proposed motion.
The proposed motion is, first of all, there's really not going to be a working group because we're going to hold it within a duly noticed meeting. So any interested party or any interested person would then have the opportunity, after the notice is issued, to come and set forth and tackle this issue. Because my sense is that you're going to have an agenda item that's dedicated to figuring out whether this list 1 through 7 should be expanded, compressed, referred to another licensee group that can do it, whatever the issue is, you'll tackle it right there. That's my understanding. And it would be a cast a wide net, come one, come all, anybody who has an interest in it.
So do we have to vote on something?
Yes.
To really,
So I'll make a motion that the MDC consider these items and hold a public hearing to see if there's a need, if they cause harm, and considering access, and to then report back to the veterinary medical board on if there's any changes.
is there a second?
Question.
Yes, Jennifer.
Would this necessarily be at the next MDC meeting or just a future MDC meeting?
I'm gonna say in my motion a future MDC
Because there's a
to
lot
be
of, a
determined.
lot of material we have yet to get.
Right.
And I think we're gonna go through the priorities as well anyway, so it would be
In
future.
that case, I'll second.
Okay, Jennifer seconds. Any other comments from the board? All right, Jennifer. Any comments from the public? Nancy?
I just have a question whether you're planning on,
Identify yourself.
Nancy Ehrlich, Carfta, whether you're planning on having a formal public hearing or you're just going to have this as an agenda item on the MDC's agenda?
I saw this as a little hearing within a hearing.
So, yes, a formal public
Kind
hearing.
of set off this within the hearing, that sort of thing. So that's kind of why I saw it.
Do I need to add anything to the motion?
I don't believe so.
Okay.
Any other comments from the public? Call for the vote?
Dr. Waterhouse,
Yes.
Dr. Sullivan,
Yes.
Dr. Nunez, Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Lee Heller? Judy Mancuso?
Yes.
Thank you, members.
Item 9, review and consider proposed regulations regarding the compounding of drugs. And so Dr. Sullivan and I have been a subcommittee working on this for some time. And it's a complicated issue, as you know, where we've got multiple federal groups that have some jurisdiction over aspects of compounding, and then there are different kinds of compounding, and there are different locations of compounding. And so we did look at some language yesterday and discuss that. I'm going to give Dr. Sullivan a chance to jump in at this stage.
Not anything really to add. We're not ready to bring it to the board yet, so it does need more work, and that's what our plan is, and get it back here.
We did hear from Dr. Valerie Wiebe, who's a pharmacist at UC Davis yesterday, and lent some excellent expertise to us. Again, we've also got a Pharmacy Practice Act we're trying to decipher, and that also just changed. They've just changed their Practice Act. USP 797 impacts sterile compounding. That's in the process of changing. So not only are we trying to get this figured out, but some of the language that we're working with continues to change as well, and we're just trying to keep on top of it. So our plan as a subcommittee is going to be to meet with Dr. Wiebe. Also, I think we're going to want to meet with Board of Pharmacy and kind of give them an idea about where we're at, what we're thinking about, and get some help, get some feedback.
Any discussion, comments on that?
Okay. Item 10, discussion and consideration of proposed amendments regarding drug information to be provided to clients. We did have a gentleman, Mr. Stoop, who testified yesterday regarding the need for veterinarians to provide more information to clients. We did offer some language yesterday. He also has a poster that he's interested in having be put up in veterinary clinics. We also did look at the Pharmacy Practice Act in terms of the duty to consult that pharmacists have with the patients for whom prescription medication is being dispensed. And at this stage of the game, really, we needed to meet with Mr. Stoop. We needed to hear what his concerns were, what he wanted, and I believe we heard that. And so we formed a subcommittee yesterday to start to try and distill all of that, and they will come back to us at the next meeting with hopefully some language that we can move forward.
Any comments from the board? Any comments from the public?
Item 11 was discuss definitions and scope of responsibility for induction of anesthesia versus sedation. Really, the crux of this issue is referenced below with 2036 Animal Healthcare Test for RVT. And the deal here is that within the shelter setting, there are many animals that need to be anesthetized in order to have them be safely treated. They are badly matted, they're injured in some way, but a veterinarian is not always present to provide direct supervision. The other component to this is that many drugs that live in the sedative category, given in a high enough dose, can cause anesthesia. And so there are two components to this. And one is if an RVT gives a sedative to a dog and the animal, or cat, and the animal becomes anesthetized, what are we going to do about that? And the discussion comes down to the focus on the intent of the medication. And then should we change the standard for anesthesia in regards to RVTs and direct supervision? And Furthermore, should we change that standard only in the shelter setting, or should we change it across the board? Yesterday, our focus was trying to understand the difference between sedation and anesthesia, which is a continuum, this thing. And so that's where we took it. And now we were ready to go to that next step. But that next step, again, if you look at 2036, falls into a previous line item 8 with SHAC and to some degree shelter medicine and what the needs are there. So that's what I've got for you on that. And again, an FYI, there's no action items on that at this stage.
Any comment from the board? Question?
Will this continue as an MDC item separate and apart from shelter medicine?
I would prefer to see it at this point just kind of put in the parking lot for a little bit and see what comes forward from SHAC and that group. Because again, I really think that it starts there, the conversation starts there.
Okay.
And then we'll see where it takes us.
Okay.
Yeah.
Any comments from the public?
What we did not get to yesterday was language that we had on developing minimum standards for spay and neuter clinics. So that's at the very bottom of this paper as item 9. Item 10 also has been sitting out there in the ether, minimum standards for mobile specialists. We have not had a discussion about this. We do not have a subcommittee on this. We do not have language on this. So those are future priorities for us. And then going out of order, but items 1 through 8, you can see what have been our existing priorities where I have lined out 2 of those. That is item 3, that's your 2027.5 language. And then item 5, which is the 2069 language.
Judy?
Was the number 1 evaluate structure and audit enforcement case outcomes? Did that have to do with the 2 people reviewing?
Yes.
So is number 1 then completed or not? That was just an initial outcome of it all, or what?
Well, the recommendation, and that was agenda item 3, so it's the first agenda item today, was that we continue to take a peek at enforcement cases at least a couple of times a year, and use that to try and help revise and refine expert witness training and communication and things of that sort.
So for number 1, it was determined by the MDC that there's no difference between 1 or 2 people reviewing the cases.
Oh, I thought in terms of the 1 or 2, you were referring to the subcommittee members.
No, I'm sorry about the review of the cases. Is that related to this number 1 evaluate structure and audit enforcement case outcome?
It's not.
Okay.
Yeah.
That's what I need.
Yeah.
Thank you.
Any other comments? Any comments from the public?
All right, thank you.
Dr. Moore. So we go on to agenda number 6, review and discuss requests from the City of LA for a guarantee letter regarding an exemption from licensure for veterinarians providing care and treatment to animals participating in the 2024 Olympics and Paralympic Games. For this, we just need a motion to support the concept. And I think Emery, do we have a new letter?
Yeah, so we have a new letter based on my email communication with the attorney that's representing Los Angeles in their Olympic bid. And I needed clarification on what she was requesting of this board. Were you requesting the board exempt veterinarians that are treating, their own country's animals, or was this simply what do we need to do to give them authority to treat the animals while they're here? If in fact LA is selected as the next Olympic site. And essentially what she's asking for, the attorney, is an explanation of the temporary license process and whether or not that would be a viable solution for the veterinarians that are coming from other countries to treat their animals while they're here participating in the Olympic Games. And it would be viable with the exception that in order for us to license anybody, they either have to have a social security number or they have to have it used to be called a FIN, what is it called, Ethan? ITIN number. So that's a little more difficult to get. Sometimes it takes several months. So I don't know what the viability is for, and I don't know how soon veterinarians will arrive here to treat their own country's animals. I did want to share with you that there is no exemption in the law for veterinary medicine, as you're aware. The medical board does in fact have an exemption for this purpose, and I do have copies of their statute if you want to take a look at it. It's not very long, but it essentially says, hey, if you're here participating in the Olympic Games as a physician in terms of treating your own athletes, you can do that for the period of time that you're actually here, and you can only treat your athletes, and then when the Olympic event is over, you don't have any authority to do anything, even for your own Olympic or your own persons from your own country. At this point, what the Olympic Committee is asking of the Veterinary Medical Board is essentially support for their bid for the Olympic Games in Los Angeles in 2024, and that the board will work with the committee to find a way for these veterinarians to be able to treat their own country's animals if the games are here in California. So that's where we're at.
So I would have a couple of comments or questions, and one is, would it be spelled out that the Venezuelan veterinarian would only work on horses from Venezuela, or horses are the only animal we're talking about here?
I believe so.
Or could there be a possibility of, the Venezuelan veterinarian working on Venezuela and Brazilian, or, is there going to be more than one country that one veterinarian might be working for?
My understanding is, and this is just based on what the exemption is in the Medical Practices Act, is that it's your own country's animals, your own country's athletes for physicians.
Yes. And that, would it be spelled out a certain time period for, is it a month? 3 weeks, 4 weeks, 5 weeks, 6 weeks, how many, I don't know how long these horses have to come here and acclimate.
Yeah, the equestrians pre-trials start, I think, early.
I don't know.
I don't know
Yeah.
either.
What
These
sort of
are all
time
questions.
period? And Kurt, are you suggesting that we create a new exemption? I hate for to ask a veterinarian to come here and take a 3-day course on regionally specific
Right.
diseases when they're only going to be in LA.
Right. And they're only treating their own animals
They're
for
only
the
treating their own
purpose of the
animals.
Olympics.
Right, so,
Yeah.
Madam President and members, I'm conflicted here. Thank you for your very cogent explanation, Ms. Delmanaya. However, what you just said isn't what quite was in the letter. Because essentially, what the letter is saying is I guarantee team veterinarians will be enabled. If we have the situation that you just talked about, where they can't get the ITM, they can't get an SSN, we'd be precluded from licensing them, in my opinion. So it may be a situation where we say, the board recognizes the need for, home country to treat their own animals, and this is an option available, and the board would certainly consider supporting an outright statutory exemption like set forth in the code. I just, as the board's attorney, I'm a little bit of heartburn saying I guarantee the team veterinarians will be able to serve. I don't think anybody in this room can make that guarantee. That's a little something. I think we can fully support the concept that you may want to seek a statutory exemption. I think you can say this is the avenues that are available with temporary license, but to be a guarantor of some future event is a little bit problematic to me. I think it just seems a little bit problematic as we read comments.
So when I reached out to the attorney, and I will read this so there's further clarification, the purposes of meeting this bid requirement, for the purposes of LA meeting their bid requirement, the attorney is asking for an explanation of the current temporary license process, including the 3-day course requirement. Are there any additional concerns about the logistical feasibility? And that was my concern, is how are they gonna get this either ITIN number or social security number in the amount of time they need it? And then absent any additional concerns about the 3-day course option, would you be comfortable with signing the attached letter? So that was their request from the attorney, and this is via email. Now, we are, it is to our disposal, if you will, to amend this letter. We don't have to use this letter. They're asking for support for LA to bid for the Olympics in 2024 and some sort of cooperation from the Veterinary Medical Board that we will work with their organization to develop a process by which these veterinarians from other countries can treat those animals that are here for the Olympic Games. That's essentially in a nutshell what they're asking for. Whether or not we amend this letter, to respond to Kurt's concerns, yes, we can't guarantee anything because we don't know anything about these people coming over, but we can at least say, hey, we support this bid and we will work with you to develop a process by which you can come here and treat the horses in the Olympic Games.
You know when they decide on which city?
I don't know. I don't know what the time frame is. I know they're looking for this letter relatively soon because there's several stages of their process.
Right.
Yeah.
But if they, say LA did get it,
Uh-huh.
then there would be enough time if we needed to
Right.
write an exemption.
Right, to go, yeah, because this doesn't happen until 2024,
Right,
so we have several years by which we could write an exemption.
Sorry, Dr. Nunez.
Well, it seems like this board has the power to foil Los Angeles' attempt. I hope we're going to get tickets to the opening ceremony out of this. But having said that, since the Olympics were in Los Angeles in 1984, and I marched as a member of the Olympic All-American Marching Band during those opening ceremonies, and I still have my uniform for it. Can we see what they did in 1984? Was Sue Garrett the director in 1984?
Yeah,
And does she have
they
any?
didn't have an exemption, so
Did
if they did it without an exemption.
Yeah.
Okay.
I was gonna ask along that line, did the medical board do these for the '84 Olympics? Is that when this went into effect, or for that
Actually,
reason?
it was amended in 1980, so perhaps.
Probably that was the
Probably.
mid time.
For the
It probably
84.
was.
Okay, so they did do that in
They
the
did it for the '84 NBC.
I don't know.
I agree with Dr. Nunez's question, and also Atlanta had the Olympics as well. It would be interesting to see what they did in Georgia.
I mean, we can look at it, but regardless, either they're practicing on licensing when they come here, whether they're practicing on their own country's animals, or we create an exemption. So since there's not an exemption, I imagine in '84, if the Olympics were here and if they were practicing, it was not under a lawful provision.
And I will say in '84, a lot of the equestrian events were held in San Diego as well. So they were not in LA County.
Jennifer.
I just have a concern and I'm not sure how to address it, but I'd like to see that the veterinarians from these other countries treating the animals here are treating in a way that's consistent with our ethics. I don't know anything about how they treat in other countries, but I know several procedures such as pin firing and things that are controversial are not done here that might be okay in other countries. I'm just saying it might be concerning to see a veterinarian doing something that would not be allowed here, but the Olympic veterinarians are doing that. So, yeah.
Yes, Dr. Miller.
I'm going to go out on a limb here, but I think in the past, the Olympic Committee actually hires veterinarians, and they may not be from the United States, they may be from other countries, but they usually have very rigorous standards, and then those veterinarians are the only ones that are allowed to work on the animals within the Olympic Park, because there are very, very stringent standards of care and what medications can and can't be used. So I don't think that every team just brings their veterinarians and allows them to practice. So I think they oftentimes wish they could. They come, but I think the Olympic Committee has to recognize and invite that. And if you look at this medical letter, you'll see the same. They're basically hired by the Olympic Committee. I think, I'm just going out on a limb, but that's what I remember from Atlanta when I was there.
So if they just want support, can we just cross out the guarantee part and just give them our support?
Well, I think we need to explain the temporary license process, which I'm prepared to do, and my concerns about the logistical problems they may face if they are bringing veterinarians in from other countries would be, how do they get a social security number, an ITIN number, and they have to be printed, and there's other things that go along with getting a temporary license that require, you know, a couple of months at least. So depending upon when they arrive, it may not be a viable option for them to get a temporary license.
I think it will be. I think that they'll announce way, years right in advance kind of thing.
But they'd have to come here to get fingerprinted. They can't get fingerprinted elsewhere.
What's the viability of us having a very strict exemption for that group, for that event? And we'd have time, I'm assuming it'd have to go through regulation and we'd have
It'd have to go through statute.
It would.
Yeah.
Well, I think that's a cleaner operation, because you look at temporary license, they have to be in good standing, they have to have a supervision, and there's criteria there that is more than just social security numbers.
Right.
And if you really think this through, I mean, if there was an actual complaint and we had to do an investigation, are we going to go down to Venezuela and investigate the Venezuelan veterinarians? It's kind of crazy.
So,
I think a cleaner way of doing this would be to ask some of the LA legislators to carry a bill for us to do an exemption statutorily, and I don't think that would be a problem. I don't know if we can use the word guarantee, but I think we could maybe use a stronger word than support.
Okay.
So I think if we had a letter just talking more general terms that, we support this bid and we'd love to see the Olympics come to LA, and we'll do whatever we can to try and make it work.
Yeah.
Something along those
Through a
lines.
statutory
Just very
exemption.
broad.
And the attorney from LA did say, we're not at the point in time where we would request you carry a bill, because obviously they're premature in the process. But at least a letter saying we're aware of it and we're working towards a goal by which, if this does come to pass, veterinarians from other countries could in fact work on their animals here for the purposes of the Olympics. To answer your question, Dr. Waterhouse, the Medical Board of California limits the exemption to 90 days.
There may be other boards that are affected by other than, obviously the med and the vet med are obvious, but I wonder if there are others that will be attending to athletes that are gonna be in similar.
They are.
So LA is requesting this of
For several boards. So this
Okay.
came through the governor's office.
So we should really probably check and see how everybody's handling
Yeah.
this.
Well, the medical board
The good
doesn't
bit.
have to because they have an
Right,
exemption.
there is it already in there.
And some of the other boards do as well, but I can check with like physical therapy, dental, and see if there's other. I think for our purposes, since every healing arts board is a little unique in how they would handle exemptions or exceptions, I think it would be perhaps a prudent process to have Kurt work on a letter that expresses what you said here, which is we support this, we'll move forward with, some provision for this to happen. And that way we're not guaranteeing that it's gonna happen the way they think it can happen here, but there will be a process by which we will move forward with whatever it needs to be at that point in time. I know.
Okay, do we need a motion? I think we need a motion to support this letter.
Right, I think you would, Madam President, members, I think you would need a motion to direct the executive officer after consultation with council to send this letter that would say.
Kurt, we wouldn't do anything without consulting our counsel.
Yeah,
So moved.
I want to be so bold though, so I think the first paragraph is okay. I think the second paragraph is okay. I think it should be regionally specific diseases, not regional specifically diseases.
Well, we're not gonna have them do the 3-day course anyway.
Okay, you're not gonna have them do that anyway,
No.
okay. So then I think the question I have for the board is, one of the things we could say, the board would conceptually support a statutory exemption for this purpose, this limited purpose. Right, but the question is, are we seeking, in your letter, is the board committing that we're gonna go find an author, or we're just gonna simply say, we support conceptually, because there's a huge difference.
I see it as we support this conceptually because we don't even know if it's gonna come to LA.
Exactly, I don't wanna believe, I thank you, Dr. Waterhouse, I don't think the board would want to be in a position, essentially, some years from now, that we're gonna go find an author.
Can you get that microphone a little closer?
Okay. Who knows the composition of the board or whatever, so, thank you.
So moved.
Is there a second?
I second.
Any other comments?
As a matter of public record, I do not expect tickets to opening ceremonies. Just to be clear.
Any comments from the public?
But I want to.
Call for the vote?
Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Dr. Nunez.
Yes.
Dr. Nolan.
Yes.
Jennifer Laredo.
Yes.
Kathy Bowler. Lee Heller and Judy Mancuso.
Do you have cough drops? Okay, on to agenda item number 7. Ethan? You're up. Update on registered veterinary technician school reporting pursuant to section 2064 of Title 16 of the CCR.
Yes, correct. I Googled the Olympic thing. It's September this year. They'll decide. On the Olympics, the decision is going to come down September of 27. I'm sorry, September. September 2017, yes.
And you did tell me that, that's right.
Yeah. I Googled it again because I didn't remember which month it was. Okay, so I have a memo in front of you. It's a continuation of our approval for application with California RVT AVMA schools. So what I've prepared is a spreadsheet with the compiled final list of this application process. All 19 schools have been reviewed. There were some schools that were not completely in compliance. I will say, though, regarding the word compliance, is the finding for the majority of these cases where there was just a simple lack of documentation confirming statements that were made within the application. So that's our next step. We're sending letters out to get final confirmation via documentary evidence of some of these areas of concern. And then we'll hopefully be able to sign off on the rest of the schools. There were a few, though, as you can see in the spreadsheet, that were fully on first pass, completely in compliance with the areas of concern. I'll take questions if you have them.
Yes.
This list of 16 that you have on the top, what are those 16? Are those
19? The schools?
16 criteria.
the 16 criteria?
Oh, yeah.
Are those, can you clarify what those are? Are those actually what the California board requires in addition to AVMA accreditation?
Right. Those are straight pulled from a regulation that spells out specific requirements they would meet for California approval. So when we had the application developed, these are the 16 specific items we asked for verification of compliance. And I cited specific sections of regs within the application.
So the purpose of this was to determine if those additional requirements we have would promote consumer protection, as opposed to not requiring them and just accepting AVMA accreditation.
Well, yeah, that was the genesis of discussion, is the comparison between AVMA accreditation versus California approval, and were they meeting the California standards?
So what we're seeing is that there are a couple of things that did indeed slip through the cracks.
Yeah, and in that sense, I'd say in a couple areas, well, most areas, there were statements made in the application that said, hey, we're doing this, but I would still like to see some documents, like outlining who the faculty are and their qualifications was one example. Not all schools included like a resume, for example, so I could verify the education and training of that particular faculty member. Whereas they may have just said, yeah, they qualify because.
So these areas of non-compliance were mostly with faculty resumes, or which criteria was the most commonly one?
The one I saw based on the chart is
Number 15?
15 and 16, yeah. The disclosure of pass rates and disclosure of transferability of credits. Yeah, so what I found is we talk about is it readily available? And it wasn't always as easily readily available as I think it should have been. There was one school in particular that had some outdated numbers from like 2014, so we'll make sure they clean that up. I wouldn't say it was egregious, though. It was something where I think they could just do a little bit better job of making sure it's clear to the students.
So I think that was Ethan's comment about non-compliance versus they didn't show us, they didn't demonstrate by documentation that they met that
Yeah.
requirement. So where it says non-compliant, it's because whatever they submitted up till this point in time is not sufficient. So we don't, it's not that they don't have those things posted, it's either not readily available or clear enough for the student. So we're making suggestions to these schools that we think your posting needs to be much more readily available, obvious to the student, especially when it comes to
Right.
exam pass rates and disclosures on their transferability of credits.
So this is a work in progress, so you're following up with,
That's, yeah, we continue to follow up with the schools and ensure that they submit everything they need to, and then offer those suggestions to make sure that they're meeting the standards that we've outlined.
Dr. Nolan.
Thank you, Ethan. This is great information. Do you have a timeline and a plan for how you will follow up and when you will expect them to make changes?
Right, so letters will go out in the next couple of weeks. I was hoping to do it before this meeting, but I didn't manage to make it. But yes, letters will go out soon. And especially the ones that are fully compliant, we'd like to let them know.
Question. So then, this is in addition to what Dr. Nolan said, then how long do they have to get up to date? Are you giving them?
We initially gave them 60 days to submit documentation, so it'd be somewhere in that range, 30 to 60. And again, it's not like the first pass through where it's like, hey, we're coming at you cold, give us all this information. This is what we have. We'd like to see more of it.
Then
So I think they can respond more quickly.
About the pass rates
Mhm.
and transfer credits, since that is so important. Are you asking that it's available off the home page, someplace really obvious? What is your criteria?
Yeah, well, so I compare it to, I was completely new to seeing how these schools complied. Some of the gold standards, so to speak, were ones where they had a packet for the students, or either on the website or a actual hard copy packet where they demonstrate some of these things like the pass rates.
Because to be honest with you, if I was shopping for a school, I'd probably go and want to go look at that immediately off everybody's
Right.
home pages and then determine, where I want to go, obviously. So it seems like there has to be very clear criteria, like it should be off your home page or 2 clicks away. It should be as of the last year, stuff like that.
Yeah, that's exactly what we're looking for.
Any other comments? Any comments from the public? Thank you, Ethan.
You're welcome.
On to agenda item number 8, review and discuss reciprocity issues and license eligibility for veterinary applicants who possess work experience in a foreign territory, potential revisions to existing reciprocity statute 4848B1. So this is a framework for discussion. We discussed this at the last board meeting, and our astounding counsel, Mr. Hepler, was going to do some research.
Right, so, thank you, Madam President. I was going to refer back to some work that I had done with the medical board about folks that had graduated from a foreign medical school that was approved. As I researched the statutes, I would find out there had been some legislative revisions that had rendered my beautiful, thoughtful analysis obsolete. So I think we're back to kind of respectfully where we started. And that is, historically, it's been the policy as the board reviews an application of this statute that you have a license in another jurisdiction, and you practice in that jurisdiction. Correct me if I'm wrong.
Well, they've had a license in either the United States or Canada,
Right.
but yet they've practiced in a foreign territory not within the United States or
Correct.
Canada.
And I think the issue was, you hold this license, but you've never practiced it. You haven't practiced in one of the specifically enumerated places, the Canadian province, the United States territory. And so there was a question, and the gentleman that came to the meeting previously had suggested that, that I have fulfilled that because I have practiced, I hold the license, but where I practice and where I hold the license aren't exactly the same. And so, having been with the physician assistant committee, now board, several times, as I explained before, I think the issue was, does the board wish to essentially revise, or in my words, clean up the statute to say it's just not a matter that you hold the license in one of these other states, it's that you practice there. And so, but by that I mean revising the statute to remove all doubt. So there really is no room for interpretation. Because I think we have a little bit of an interpretive question. But just because I think that's what the statute means, there's certainly 58 or more superior courts in this state that can disagree with the board's position. So my advice would be that the board decide whether it believes that a statutory revision is necessary to remove the ambiguity in my mind of the statute, and I would suggest that would be a good idea.
Dr. Sullivan.
Well, I was around when this was written, and that was the intent. And I would agree.
Which was the intent?
The intent was that the person practice in that state for a period of time where he has a license before he can apply for reciprocity. And I think we need to make that clear by the changes that were suggested.
Other comments? Judy?
I would just say, what's Kurt's suggestion on making it not vague?
Yes.
Yeah,
Yes,
I
it
would
definitely
just,
needs to be rewritten.
Right, so I would amend, and I don't have the language in front of me,
But there are several different aspects to this. So say I had a license in New York. I practiced in New York for 5 years, but then I went to Japan. I was in Japan for 5 years. And then I come back and want to get a license in California. Well, in my mind, yeah, I think I should be able to get a license in California. Because I practiced, I have a license from the U.S. I practiced in the U.S. for 5 years. So that's one thing we need to look at. Another one is, as the gentleman that was here last meeting, he's board certified in internal medicine. I think anybody that's board certified should be able to come get a license in California without sitting for the exam. I mean, asking a boarded intern to sit for the NAVLE is, I'll put it in attorney terms, like asking the Supreme Court Justice to take a business law class. But that's my opinion.
which attorney, which Superior Court or Supreme Court member are you talking about?
So there are, all right, maybe we need to have a certain number of years they have to practice. There are so many years in the States before they go practice in a foreign country. And so there's several different things to look at. Kathy?
I was thinking that your example of 5 years and 5 years could easily be, I practiced, in Iowa in 20 years ago, and then I went to Africa or went to Australia, and I've been practicing there. And now I want to come back to California. That may be very different.
Jennifer?
If I'm not mistaken, at the last meeting, there were some concerns over where they had been practicing because not all programs were created equal.
Yeah, Mr. Rita, that's exactly the point. There could be some, using hyperbole again, there could be some foreign jurisdiction where I said that I practice veterinary, I practice veterinary medicine, and veterinary medicine may not even be regulated or a license required there. So the theory would be, I understand it, after conversation with Dr. Sullivan and doing some research, is exactly that, is that you would practice in a place enumerated here because they recognize the necessity to license veterinary physicians, and if something went awry, they would take discipline. They could potentially report to the NPDB or whoever, so that you could find information about that. If you went to, say, Antarctica, that's hyperbole again, and you said I practice veterinary medicine, that may be of no moment, as the lawyers say. It may not. That may be illusory, because Antarctica probably doesn't require licensure to provide to practice veterinary medicine. So that was kind of the theory.
Dr. Sullivan?
I did practice in a foreign country for 2 years, in Brazil. And the criteria of practicing for 2 years in the country is totally irrelevant as to what this is seeking. That the practice there is totally different job description, totally different approach, totally different philosophy. So there's purpose for the recent time. We're not, and I think we need to also mention that we're not limiting this person from their livelihood. They can go to the state that they do have a license, and they can practice for 2 years. I think it's maybe even a little less than 2 years, and then come in reciprocity, or they can take the test. So we're not limiting anything. I think the criteria that was set up then was discussed ad nauseum. There were compromises made, and there were reasons to have this criteria. And I think it is sound, and I would be opposed to changing it other than clarifying the intent.
Dr. Nunez?
Well, I was going to say that it has to be, if we were to add language to what the statute says, could we add, has practiced clinical veterinary medicine in a U.S. state, Canadian province, or United States territory? Would that fix the issue?
It does,
Okay. Because it would be impossible to say which countries are good.
Yeah.
Say that England and Australia is good, but Djibouti is not. And I had to say Djibouti in the beginning before my time was over. So I would make that motion to add that to the existing statute.
Dr. Sullivan?
Just to clarify, there are practices in Brazil that are top quality, don't get me wrong. The practice I was in was extension work, which would qualify as practicing, but it was not dealing with anything that remotely is a practice, clinical practice setting. So I don't want to leave the wrong impression there.
Cheryl? Kathy?
I agree. I like Mark's language. I just want to articulate that I believe even that language would not satisfy the individual who came to us last time.
That's right.
He basically did not want to take the test. He could have taken the test. He wanted to come to California, and did not feel he should have to take the test, and I understand the board certified question. But just as long as we're all on the same page on that. But I technically like Mark's language.
So I would like to see language exempting board certification, exempting individuals that have board certification, and that they are able to
So,
get a license. Okay, Judy.
they're board certified in the United States. They go away. Where do they go? To internationally or another state?
Yeah.
Come back if they wanna. Would it be within a certain time period that we're board certified? Or is it just forever?
Well, all that's yet to be determined, but, you know, for them to get board certifications, that means they have been practicing here. They have to practice to get board certified.
Right, I understand. That's a much higher bar.
So I think the issue of board certification can be made on a second motion, but I believe I do have another bold motion awaiting a second.
Well, I think your first bold motion, the board may want to consider if there's a second or
I'll second it.
Okay, we have a second. Can you,
It's just to add, in the, where the statutes, B1, the applicant holds a current valid license in good standing in another state, Canadian province, or United States territory, and within 3 years immediately preceding filing an application for licensure in this state, has practiced clinical veterinary medicine in one of the United States, Canadian province, or U.S. territory.
For a minimum of 2 years.
Yeah.
So it's essentially just inserting in another state, Canadian province, or United States territory after clinical veterinary medicine. Yeah. And Judy seconded?
Yes.
Judy seconded. Okay. Any other comments? Yes, Dr. Nolan.
I'm sorry, but what you're saying then is instead of using the word another state, you would say in the United States, Canadian province, or United States territory?
I guess.
Because it could be a combination of California practice at another state and whatever, right?
I think it was supposed to replicate the line that was above it, in another state, Canadian province, or United States territory.
The
So
line
it's just
above-
taking the line above it and inserting it after clinical veterinary medicine.
If the line above it says another state, just say another state. I'm fine with that.
Any other comments? Any comments from the public?
Alen Moon Carvta. I just want to be sure that this regulation won't impact our military who serve abroad during their time of service. Because in the military, you don't always get to choose where you come back to.
And for military purposes, there's special provision that exempts their work experience is considered for the purposes of reciprocity.
Any other comments from the public? Call for the vote.
Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Dr. Nunez.
Yes.
Dr. Nolan.
Yes.
Jennifer Laredo.
Yes.
Kathy Bowler.
Yes.
Judy Mancuso.
Yes.
Members, before we go any further, I'm inherent to that motion is we're going to sort of like what we did with the LA issue is that someone is going to, you're hoping to essentially effectuate that legislation, so we're going to have to go out and like seek an offer or something like that. I'm sure that's inherent in the motion. Okay, all right.
Okay, can we talk about the second part of that? Are there any other aspects that we want to go ahead and
So, I motion that there be a B2. For the purposes of reciprocity, the board shall waive the examination requirements of subdivision A and issue a license to an applicant to practice veterinary medicine if the applicant meets the following requirements. And 2 would be, is it diplomat of American College of veterinarian.
If they're board certification in any specialty, how should we say this? What's the
You could
language?
say that board certification in specialty in any practice.
Does that cover?
If they received their
Would that be anything?
degree.
The question I have, the question is, as the board goes through, just from a purely legal perspective is, would that substitute for the license in good standing? Would that substitute for the 3 years? What is this substitution about? That's the question. Not on the merits, just want to be clear for drafting purposes, what the board certification will essentially substitute for.
It's a good point, because a person could potentially not get a university license, if this is an option available.
So I would say they would substitute for the, they would still need a current valid license and good standing in a state in the US, Canada, or US territory, but that it substitutes for the,
And
2 years of recent clinical practice.
Okay, so then what remains is under the proposal, which we haven't really got to yet, but I feel it's gonna be bold, is that you still need the license from, one of our nifty 50s, the Canadian or the United States territory.
Yes.
You still need the 2944 employment practice, but it'll substitute for the minimum of 2 years.
That is 2 years.
That is,
I
so
think
the
it's,
2 years does not have to be practiced
The
within the US.
2,944 hours.
you hold
is
a
2
current
years.
license in good standing in another state and are going to get certified.
So the 2 years, just because it's gonna get confusing, the 2 years and 2,944 hours is to make sure that it's full-time practice. So that's why there's a number of hours and 2 years. So it would be substituting for both of those. If you were going to do this, and again, the proposal hasn't completely been fleshed out, but you would not necessarily need subset B2.
Right.
You could just say, has practiced clinical veterinary medicine in another state, Canadian province, or United States territory, and then for a minimum of 2 years and completed a minimum of 2,944 hours of clinical practice, or holds board certification.
That would work too.
Yes.
That's very good.
And then that way,
Very and define board certification.
and that way you have that first you have that first sentence, which is the license in good standing. And then you have that second layer, which is you practice in the United States or Canadian province for this long. And the third layer is or you will hold a certification. And do you want to say board certification from AVMA, sorry?
I have a concern with that. Admittedly, the board certified veterinarians have gone through extra training, but if we have a doctor who's been focusing on one thing, say ophthalmology, for the past however many years, now we're telling them they can come back to California and get a license to practice essentially anything. They can be practicing orthopedics.
Well, they can do that at any time.
They can, and I've been in the situation where I've asked a board certified internist a dermatology question. He looks at me like I'm crazy because he doesn't do that, so I have a concern about that issue.
If they're board certified, they're gonna come back and work in that area.
Hopefully.
But anybody could do that anytime. Any other
I
comments,
apologize.
Dr. Sullivan?
I'm sorry, I'll defer.
Dr. Sullivan.
I do not agree. I think this is not the intent of reciprocity. Reciprocity is the intent of a clinical equivalency, and I think we're ignoring the intent of the original statute, and I will be voting against this.
Any other comments?
Members, I'm sorry, Ms. Bell, I just want to point out, as your attorney, as I read, let's just take the bottom of the page, subdivision 1. I see those as 3 discrete things. Number 1, you hold the license. Number 2, 2 years. And number 3 is 2944. So in my opinion, under strict construction, reading that thing, those are 3. Now, if the board has interpreted 2 years equals 2944, I'm not gonna get in the way of that, but as I read the statute, that wouldn't be the way, that would not be the way that I would review it, because it's disjunctive set off by commas, 1, 2, and 3.
That's true.
So, you know,
Should have been written differently.
I would agree with that in that the purpose or intent was to mean that that person was working full-time during that last 2 years. That they weren't getting those hours in over a period of 5-6 years doing part-time work. So that's the purpose of that.
It should have probably been written by completing
right, something to that
a
effect. So,
minimum of whatever
so
hours.
I don't, you know, like I said, I'm not gonna get in the middle of that. If the board, whatever the board wants to assign the substitutionary value, the board certification, which I'm presuming will be the lines of holds a current board certification, we'll figure out the name later. You know, how exactly I would word that, because I think conceptually can move forward, that's fine. I was just pointing out, as it struck me that I saw things a little differently, but that's a no. So,
Dr. Nunez.
So since we are in agreement with the clinical training aspect part, we voted on that. There's been some valid points raised in regards to the board certification part. May I suggest that we move this off to MDC? I think it's an issue that deserves consideration. And I think there's a lot of questions that need to be asked, which is why we have MDC
And
Kathy.
and DAC.
I don't want to be so bold as to agree with Mark, but I almost, as a consumer on the board certified, because I still have questions on the actual definitions of it better, a little bit more. I'm wondering if that might be a better approach, is to have MDC take a look at elaborating on that language and coming back with a cleaner language than we're going to do today on that. In addition to what we already.
Dr. Nolan.
Well, yeah, I'm happy to weigh in, and I guess I look at reciprocity as a privilege, not a right. I think it was established as a way to not impede the practice of a general practitioner that is moving from state to state, but I have some of the similar concerns that Jennifer has, that it is something that doesn't necessarily need to be mandated for a board certified practitioner. That's how I feel about it. So I guess I would probably be voting no if that wording came out the way we just talked about it.
So can I make a motion to refer to MDC
Yes.
and DAC?
So your motion is?
To refer the issue of reciprocity for individuals holding board certifications to the multidisciplinary committee.
Is there a second? Any other discussion? Any comments from the public?
Nancy Ehrlich-Harta, I have a vague recollection that the Federal Trade Commission had some kind of ruling about board certification from AVMA not being able to restrict the concept of board certification just to AVMA, that was a restraint of trade. I don't remember the context, but I think that you want to make sure when the MDC looks at this that you take that into account.
certainly.
Thank you. Thank you. Okay, call for the vote.
Dr. Waterhouse,
Yes.
Dr. Sullivan,
Yes.
Dr. Nunez,
Yes.
Dr. Nolan,
Yes.
Jennifer Laredo,
Yes.
Kathy Bowler,
Yes.
Judy Mancuso.
What's the motion? Refer to the MDC. Refer the question to the MDC.
Of the boards.
Yes. Yes.
Okay.
Yes.
Okay, and we're going to take a short break. Should we come back at 3:00? Okay. We are going to reorder the agenda again. We have people here from OPES, and so we're going to go to 15C. Yeah.
Bye. Bye. I'll go over here.
All right. I've never seen it come down. It's always been just right there, so. Sorry, I thought we were going after one more of your agenda items, so I'm trying to coordinate. Okay.
You can grab it if you need.
I'll leave it here. This is good. Just make sure this is gonna do what I need. Yeah. Okay. Hello, everyone. Just kind of move this over just a tiny bit, for those who can't see me. Okay, so my name is Camilla Holloway, and I'm here with the Office of Professional Examination Services. So my background is with, I've been working with the Veterinary Medical Board's examination program for about 4 years now. I'm still out of breath from almost being hit by this thing here, but okay. So my background is in industrial organizational psychology, so I've been working with testing standards for quite a while, and of course with VMB now for 4 years. I have Heidi with me. She's the chief of the Office of Professional Examination Services. And today we will be having just a short presentation on the veterinary law examination and the California State Board exam comparison study. Okay, so in an effort to eliminate unnecessary barriers to licensure, the goal of the study was to determine whether overlapping content exists between the VLE and the CSB exams. Okay, so our agenda today in this presentation will just be to discuss the California Veterinarian Licensure Examination Program Protocol. Then we will discuss the occupational analysis, just really briefly going over the process of how we get to the third bullet, which is the California State Board Veterinary Examination Content Outline. We will also be discussing the VLE and the CSB comparison study process and the study outcomes. So the options and the OPES recommendation amongst those options. Okay. So just
Don't forget the computer is here, so you have to point.
got it. Okay. So to start, OPS's mission is to protect the interests of consumers by supporting the Department of Consumer Affairs and its regulatory entities in their commitment to establish and maintain licensure examination programs that are fair, valid, and legally defensible. The Veterinarian Examination Protocol is covered in codes CCR, which is California Code of Regulations, obviously, 2014, and the Business and Profession Code 4848, which delineates the program as passing the NAVLE, which is North American Veterinary Licensing Exam, the California State Board Examination, and the Veterinary Law Examination. I'm sure all of you are familiar with that. So the NAVLE is developed by the National Board of Veterinary Medical Examiners, and it's currently 360 items, covering comprehensive standards for veterinary medical practice, and it uses the Angoff criterion pass point. The CSB, veterinary examination, is developed by OPES, and is currently 100 items with comprehensive coverage of 9 different content areas regarding California-specific veterinary medical practice. And again, we also use the Angoff criterion for setting the pass point. The VLE is currently 32 items and covers the California-specific codes and regulations regarding the Veterinary Medical Practice Act. So that's 80% pass point, which not only was the exam developed by the board, but also the pass point was set and at the pass point of 80%. So an Angoff criterion pass point is based on a process that's consensus-based with subject matter experts in the practice. So we facilitate workshops at OPES to determine what the pass point should be, and it's based on the difficulty level of each of the items as they pertain to qualified candidates upon entry into the practice. Oh, I forgot, that's right. So the Office of Professional Examination Services, what is our role? OPES is in contract with VMB to develop the CSB only. The content of the CSB was determined by conducting an occupational analysis of the veterinary profession, wherein the following are delineated. It's the critical job tasks, so actions that you will see, observable actions, and critical knowledge that's needed to perform those tasks, those knowledge concepts that you need to successfully perform the task. And the focus is always upon entry into the practice. So why are occupational analyses critical in examination development? Both legislation and professional testing standards require that examinations are job related. So the content domain of the licensing examination should be defined clearly and justified in terms of the importance of the content for credential-worthy performance. And the standards that we follow are from the standards for psychological and educational testing. Those are our standards, and particularly 14.14 in the standards. The OA defines those tasks and related knowledge needed. So that then forms the basis of the exam questions rationale, which in turn forms the basis for legal defensibility. Okay, there we go. So the occupational analysis process, in a nutshell, begins with performing background research. So testing specialists will review profession-related materials, literature, such as archived OAs. We'll look at association materials, and this is all a part of our background literature research. We will also conduct interviews with subject matter experts so that we can help to refine that list of tasks, as I discussed before, tasks that are actionable things that we'll see within the practice, and the knowledge that's necessary to perform those tasks. The interviews can either be on-site or they can be over the phone. Typically, we'll have about 7 to 10 interviews. It'll be with a diverse sample of subject matter experts, so by location, work setting, focus of their practice, so they can be in a hospital setting, lab, what have you. And in those interviews, we'll also sometimes do these on-site visits, which will allow us to look at some of the tools of the trade, observe some of these actions being performed, and the procedures being followed. So once we've conducted these interviews, we then have what we call our preliminary list of tasks and knowledge. So we'll then conduct 2 workshops. They're usually about 2 days and about 8 hours for each of those days. And we meet with another diverse group of SMEs, so that'll be between 7 to 10, and again, diversified across their type of practice, where they're located, how many years in practice. And then we're able to sit with them and kind of not only just identify what tasks may be missing from the comprehensive listing, but also just review what's existing, see if there need to be any edits to make sure that all the tasks make sense, and that we have associated knowledge statements for each of those tasks that we've listed. We want to make sure there's always a relatable knowledge, because we need to test on that knowledge they need. So we sit with them in those 2 workshops, and each workshop, again, has its own group of subject matter experts. So we'll review those and then finalize those task listings of the actionable things we'll see, and then the knowledge that's necessary. We'll finalize those lists. We also finalize what we need as demographic components to the survey that we're trying to put together from those tasks and knowledge statements. We need to have a way to then create a quantifiable way to look at how critical each of those tasks and knowledge statements are to the field. So in order to put the data into context, we have to ask our subject matter experts in those workshops, what are some of the things we need to know about the subject matter experts? Do we need to know, like I said before, the location? We need to make sure we define where we need to have all of our locations, so we can gather data on that and on work settings and on how many years of practice and what types of animals they treat. or what their specialties would be. That way, when we look at the data, we can put it into context. So that also helps us with monitoring the survey process. So once we've finalized our demographic variables and our task and knowledge lists, we create a questionnaire. We send that out to a sample of your subject matter experts, so all of the veterinary practitioners. Then we start monitoring the data that comes in. We make sure that we're looking before we decide to cut off the survey and say that we have an acceptable number of subject matter experts. We want to make sure that we're monitoring it and going over the data that we have to see that it is diverse. And then we discuss that again with our board representative to ask them, okay, do you feel that this is now that we've reached all the numbers that we're looking for within what will represent the profession? Then we, of course, take that data and analyze it. Once we've cut off the survey and we've decided we're going to analyze that data, we're now looking at the criticality and the way that the subject matter experts rated each of the tasks and knowledge statements so that we can put the data into a listing of what the critical values are for all the tasks and knowledge and list them in their order of importance for the purposes of a final workshop that reviews that data with the subject matter experts. So now they sit down and they look at the data that we collected. And we ask them things like, if you were to look at each of these task statements in proportion to the rest of the statements, how critical is this? You're looking at what they said in all of their ratings. Do you feel that this should be retained within a final examination content outline? So every task is looked at, and usually they'll start at the bottom. They want to look at the ones that were rated the least important. And then from that process of elimination, they can look and kind of determine what they think would be reasonable for a cutoff of criticality. Now, a task or knowledge statement that doesn't make it into the final examination content outline doesn't mean it's not performed in the workplace. It just means that it isn't appropriate for testing upon entry. So those are the things that we look at. We also ask them to weight the exam in proportion to the retained knowledge and, of course, the tasks. So they're giving us that, I would call it a blueprint for the exam. That helps us to know not only the content areas, but their weights for the exam. So things can change. We also perform these occupational analyses every 5 to 7 years. So you will then see, we just had our latest occupational analysis in 2013 for the veterinarian. So things have changed with the weights on the exam. Oh, we also, of course, I may have already mentioned this, but we have them link the knowledge to those tasks so that we know now when we're testing, not only do we need to think of a mainstream scenario to approach what the task is and what that entails, but we need to link the knowledge they would then need to perform that task successfully. So, as I was saying, we have those 2 workshops, and again, it's still about 7 to 10 subject matter experts that are diverse in their background, and we finalize all those components like the weights on the exam, and that creates the final component there, 7, which is the examination outline, content outline. I have a pictorial representation of what I just said in case everybody comes to an understanding differently, so I thought I'd give you a picture of it as well. So you have I have a pointer here too. Don't get it in your eyes. Okay, so we have the practice that we were looking at and that was defined in the preliminary stages of the background, literature research, and of course the interviews, and then we have what we developed as the I'll leave that thing alone. We have our next step, which was defining the tasks and knowledge statements in our finalized lists, and then sending out the survey phase, gathering the data, making sure we've analyzed it appropriately, and the subject matter experts have had enough time to look at it and come up with their rationale for what the weights should be, and of course linking the knowledge to the tasks. Then we have our examination content outline. That's the result of all of those stages. And from that, we then have our exam items. So every time an occupational analysis is completed, we then look at our examination item bank, which is the bank of all the questions we developed over time, and we have to relink those things to our new examination content outline to make sure they're still pertinent to being testable and the field. So we definitely look at that and examine that on the 5 to 7 year basis. We also have that item bank to be able to look at and analyze regularly to make sure those items are adhering with the content outline. So currently, The state board examination content outline is comprised of 9 sections. Section 1 is history, so taking a history of the patient, historical data that the veterinarian would collect. Examination of patient and environment is section 2. We have assessment is section 3. Section 4 is diagnostic plan, and you're seeing the weights that correspond. So we have history is 12%, and this is a 100-item exam, so you'd see that it would be 12 items. And then you have 21 items on section 2, 6 items on section 3. Section 4, diagnostic plan, was 2. Section 5, diagnostic procedures, that's 16%. Section 6 is treatment plan, that's 12%. Section 7 is treatment, 12%. Preventative care is 5%, and professional responsibilities is 14%. So professional responsibilities, the reason it's highlighted in red, is that it was the content area that we identified overlap could have been possible. So that was where we presented the subject matter experts in our comparison study with their comparable section in the content outline. And this is because that section covers the fulfillment of California and federal laws and regulations, upholding standards of veterinary practice, reportable diseases, animal movement, and disaster response. So under that section, all of those tasks wherein a veterinarian must adhere with federal law and regulation, all those tasks are delineated. And then the knowledge that's necessary. So we needed to compare those things with the VLE to determine whether or not they were being covered and if there was overlap.
Excuse me.
Oh, sure.
Are you allowed to ask questions, or do we wait till the very end?
If you'd like to ask a question, sure.
Okay, I've got a couple. First, where do you, this is my first question, where do you get your SMEs, the SMEs?
Okay, so we actually we have a liaison with the board who we present what we would need to make a workshop diverse. So some of the things we look at, we ask them to find us within a certain amount of people who are from 0 to a year of experience, and then we ask for so those are the new people upon entry, so we can make sure we're never going above entry level. So we usually ask for a large proportion of our subject matter experts to be entry level. We ask them to get us some that are between 6 to 10 years of experience and some that are over 10 years. We tell them about looking for things like practice specialty and whether they're located in Northern or Southern California. So our board liaison actually is really excellent with finding us the right people based upon their specialties and all that.
And they're volunteers, or are they paid for the period?
They are paid. They do have a per diem. They also have a workshop amount that they're paid per day. They also receive CE credits.
Okay,
So,
and then my next question,
that's for the workshops.
the slide you were just on,
Oh, let me go back.
yeah, the percentages.
Yeah.
Now, are you saying that you analyze the current test and this is the breakdown?
No. This is actually the result of the occupational analysis. So when we delineated all of the tasks and knowledge that were necessary to perform successfully upon entry, they rated those things on criticality, and then from that data, which is from the occupational analysis, from our sample of how they rated things, they then determine it's numerical at first. We look at the sum of all of those task criticality ratings in proportion. So like for history, if let's say there was a sum of all the critical components, there were 10 tasks, right? And each of them, let's say they each had 5 on criticality. So let's say there's a 50, maybe a rating of like 50 overall with all those tasks. And let's say the examination section had 20 tasks, and each of those were rated 5. And then you have 100 there. And all the rest of them, let's say they all had their own respective weights. We then are able to determine a weight based on each part of those as a sum of the whole.
And this is from the data from the SMEs?
From the OA.
Okay, so I'm wondering why diagnostic plan is at 2%.
It's probably because at the time when they were developing those task statements, I had actually asked them if we could collapse Section 4 and Section 5, but they felt it was important enough to separate it out, even though it had a very small amount of the tasks and knowledge that were associated. So in the end, it got a small weight. It doesn't mean it's not critical. It just has a smaller weight. And then, the other ones, I believe with diagnostic plan, they felt that the planning part is important, but it just didn't have as many tasks listed under
I
it.
see.
So it's not, doesn't mean that if it has a smaller weight, it's not as critical. It is critical,
Yeah,
but it just has
it's
to be in
very good.
proportion to what they determined as what would be necessary as a weight on the exam.
All right,
to get it.
thank you. Your answers
You're
make
welcome.
this more meaningful to me. Thank you.
Yeah, absolutely. Yeah, there's a lot we go over with that, so. Okay. So, when we explore examinations for comparison studies, we discuss exam coverage and what each exam's ultimate goal is. So the two circles above represent the veterinary, it's the law examination, and the CSB examination. So we have the CSB is a little bit larger. As you know, the VLE is a little smaller exam, but they're also very different. So the CSB examination is meant to test knowledge needed to perform tasks, as we discussed in that occupational analysis summary, that are identified as needed at entry into practice. Now the VLE is it's a totally different animal. It's based upon the Veterinary Medicine Practice Act and the knowledge of codes and regulations for practice in the state of California by definition. So we're looking at the knowledge needed, a written exam, practical knowledge, and then you have a recall knowledge of definition for the VLE. So two different things. Next slide. So this next example, the three circles above, and this is for the comparison study purpose, the three circles above represent the results of the analysis performed on the current exams. So an overlap was found. You have the VLE and you have the CSB exam, and B represents that overlap that we uncovered. So to get to that point of determining the overlap, we conducted the comparison study in the following ways. First, the subject matter experts had to review the VLE items and become familiar with the questions. They then had to review the 2016 California Veterinary Medical Practice Act. I may just refer back and forth with the full title or VMPA. And they established the link between each VLE item question. I flip-flop between item questions, same thing. VLE items and the VMPA laws and regs. So they determined the specific link to the veterinary, to the VMPA, we'll say, for ease of pronunciation. The next step was for them to review the professional responsibilities content area that we discussed, the one that was highlighted in red, that's 14%, of the CSB examination content outline, to become familiar with all those tasks and knowledge statements. Now I'll present a picture of what happened next because it's a little complicated. Okay, so after they had established those links of the VLE to the VMPA and then to the OA Section 9, which was that professional responsibility section, they had to link each of those VLE items to specific tasks and knowledge. So we were creating a table that gave us the code, then the task and knowledge, where they could link it to the OA. Then we looked at actual state board exam items, a sample of those items from that section. So I could see exactly what those items entail, what would they look like. So you're able to then link the reviewed CSB items, which were labeled, they're always labeled, when we have our items developed, they're always linked directly to the exam content outline. So they were able to see what tasks and knowledge were linked to each of those items. We also link the codes. When people are writing to those tasks and knowledge that are under that professional responsibility section, they'll also write in the codes that they're writing those items to. So they were able to see that and compare that to determine whether or not there were similarities or identical knowledge concepts that were being covered. So they looked at those. Then we discussed those things. We discussed what it means to have a knowledge concept covered rather than a definition. Because those things, obviously, if there's a definition, it's linked to a code, and then we have an exam item that's saying that it's related to that code, we can find that inferential link between those items and say, okay, now we know that these things can be covered, and in a much more comprehensive way. Then we're able to discuss, go to this next slide here. Items such as, topics such as, are the questions on the CSB examination assessing the identical knowledge concepts? Is the weight of the professional responsibilities section of the CSB adequate to cover what the VLE assesses? We also discussed the weight of that professional responsibility section. It's 14%. And we know that the VLE was 32 items, and that many of those questions, when they were determining what VMPA code that they linked to, were in duplicate. So some of those definitions were addressing the same code. So we needed to know that, to put it in context and say, okay, well, what do you think we could do with the CSB's exam? Can it adequately cover what's being covered in the VLE? We don't need it to be a weight of 32 questions if some of those things are in duplicate, they're addressing duplicate codes. We had to look at what do they think would be the appropriate weight then? And would it be able to be collapsed into the CSB section? So the subject matter experts agreed unanimously that all of the VLE items were linked to the tasks and knowledge of the exam content outline. In addition, the majority of the items from the VLE were related to the items in the CSB examination item bank, the sample that were presented. And those that were not directly related with wording or similar content could be covered by other questions that were linked to the same tasks and knowledge, because they had established OA linkages. So they could then be covered by the CSB adequately. So again, even if the VLE question wasn't linked directly to a already established question from the presented sample of CSB items, the VLE item was linked to existing tasks and knowledge from the OA that's defined in the exam outline. So the concept could be covered. When conceptualizing what it means to compare exam questions, one must consider the exam question level. So the VLE, I briefly mentioned that the examinees are presented with recall definition-based questions. And with the state board exam, examinees are presented with mainstream scenarios. So when we sit down with item writers, we make sure that they are looking at how they can present an examinee with a relatable mainstream scenario that they would see commonly, and they would then have to apply their knowledge of the codes and be able to comprehend that knowledge and apply it to the scenario. There may be multiple things going on, so they have to be able to synthesize information and analyze it appropriately and come to a conclusion with that knowledge. So then it's not just I'm recalling a definition. It's now how do I apply that appropriately? So my last bullet, of course, covers that. Qualified test takers can select that required action. There will only be one appropriate action they can take. We list their options. There are always multiple choice questions. They'll have 4 options, and 1 is the action they should take. So qualified test takers can then select that appropriate action. So just for another pictorial representation of that, we have recall. So it refers to simple facts or definitions that can be memorized. Comprehension refers to simple translation of information from one scale to another. So a basic understanding of a relationship of simple facts or simple computations. So both recall and comprehension are typically used for examinations in school. But if you want an application level, it would refer to the use of the rules, methods, concepts, principles, laws, and theories to the on-the-job situations. So it would refer to the use of case data so that the candidate must determine how to apply the rules and methods to a situation. And the analysis would include logical deduction to identify concepts, analyze relationships between concepts, or have a recognition of the sequence of activities. So application and analysis are typically used for licensure exams. So that also establishes a reason why it would be beneficial. Comparison study, final steps. Okay, so at that point, once we'd had all of those discussions and we'd reached our conclusion that there was that overlap and that we could find that things could be covered by the CSB, we worked together to create and finalize that table. So I had mentioned briefly that we had a table that we were working on where we had the codes linked, we had another couple of columns with the tasks and the knowledge they linked it to, and then the actual CSB items. That was our working document that we were able to establish that overlap. Then we had to finalize our options and our recommendation to the board from all that data. When we were done with that, we then prepared a memo, well, I prepared a memo for the board, which I presented, or actually gave to them in December. So it explained the outcome of the study and provided those options for examination protocol moving forward. In addition to the steps to determine overlap between the VLE and the CSB, OPES also worked with those subject matter experts to write new veterinary law examination items and to create 2 new forms of the VLE that were in accordance with those established links. So when we looked at the items and we linked them to the occupational analysis and the VMPA, we were able to then create a basis and a rationale for them to then write new items that conform with CSB standards. So that way we could facilitate all the options that we presented to the board, no matter which one they chose. Thus, in conclusion, the options were to, 1, continue to administer the current form of the VLE as it is. 2, to continue to administer the VLE using those new forms that we could develop yearly for them, and to eliminate, that would eliminate the overexposure of those examination items. That exam items, the items have been there for quite a while. So this would then give the opportunity to make sure that you have a new form and people are really being tasked with understanding and trying to, reason through understanding the codes rather than just have some memorized materials. So that would be option 2. Option 3, which is what OPES recommends, would be to initiate, there would be legislative changes, so statutory, regulatory changes, to discontinue administration of the VLE for all candidates for licensure who have completed the national, the CSB, and a board-approved veterinary training program. So option 3 would reduce the necessary requirement for licensure. It would reduce them. But it's also psychometrically sound because we determine that the CSB can cover what's in the VLE. The requisite for safe and effective practice, including the knowledge of veterinary law, would be met by administering the NAVLE and the CSB examination. Option 3 would require that the new forms of the VLE be administered as mandated until those changes, the regulatory changes, could go into effect. So we would still have our 2 new forms. Option 3, and this is further delineating what it would entail, would be only the successful completion of the national and the CSB would be required. The VLE would continue to be administered to candidates applying for licensure through reciprocity. The VLE would contain new examination items created yearly. So we'd still do that for reciprocity means. For reciprocity-based candidates to prevent overexposure of examination materials. If I can get there, okay. So in conclusion, the study will provide legal defensibility should the board choose to proceed with option 3. And this was the conclusion to our findings in the comparison study. And of course, questions. Any questions? Oh, sure.
Could you go back 2 slides to the beginning of the third, that one? What is a board-approved veterinary training program?
Typically, it was in the Veterinary Medical Practice Act where I saw the board-approved program. So like all of your,
No, we're talking.
no, the actual training programs,
DVM.
the way they're set up.
So from a board-approved, accredited, or recognized college.
Oh, got it.
Correct, that's better worded, yeah, thank you. Yeah.
Yeah.
Thank you.
Sure. Yes, Jennifer. Oh, sorry, Mark.
So they get that last part in veterinary school, that training?
Yes.
That would be like schools, yeah, the train.
So, I mean, you did a good job of explaining how there's no need for it because it's duplicative and that by eliminating it, it's not going to result in any loss of consumer protection. You didn't mention, but I assume that it's going to save money.
I'm sure, because there's a lot of processing that's in place for that. You have
Yeah.
to Scantrons and printing.
Save
And,
money for this board,
absolutely.
and it's gonna save money for veterinary applicants. I feel
Right.
bad for the RVTs, it doesn't apply to the RVTs, any of this. I'm thinking about you.
Is this,
Sorry, my turn.
sorry,
No, it's fine.
I just lost my voice this morning.
Oh, no.
Is this something we're supposed to vote on
This would be a
today,
discussion.
or-
Yeah, it'd be.
So no, we're not taking a vote today, this is for informational, and so it'll be agendized and be on the next meeting, discussion. I think, one thing I would like to know, which I'm sure you're gonna be looking at, is how, this certainly isn't the most important or an important point, but how is it gonna affect us financially if we eliminated the
Right. So there is a financial impact to eliminating the exam. And that is, you could look at it as it's offset by the amount of time it takes for staff to mail out the exam, to wait for exam results. So I mean, there is some workload associated with it as well. And I believe it would be easy enough for us to pull the financial data to see how much revenue we'd be losing if we eliminate the exam. It's definitely not going to require any staff cuts, meaning that, you know, it's not associated with an actual position. However, there is some revenue associated with it, and that's a valid point. But Judy, to speak to your question, this was for information purposes, so that the OPES could report back to the board on this overlap they found recently when they did the occupational analysis, and then it would be agendized for the board to consider whether or not that statutory change is something that you folks are interested in pursuing. Because it's not by regulation, it's by statute that we would have to tackle this first.
Which it is, so in our, when did we meet, January? No, wait, December, what was our last meeting?
October.
In Riverside.
October.
Okay. At that time, we got a presentation, and that was from OPES, Heidi was there. And that was about auditing the test, right?
That was about the veterinary technician, so we're doing the occupational analysis for the RVT.
Okay, so that presentation was not related
No.
to this presentation, okay.
No.
I think Anne Marie may have answered my question, but it was which of these three exams is the take-home mail-in exam? Is that the?
I had a question, you mentioned that a memo, OPES prepared a memo. Could we get copies of that? It was
It's
given.
in your packet.
Oh, it was.
Yeah, so under 15C, that memo in there speaks to behind the statistical data.
Oh, here,
There's
sorry.
a memo to Ethan,
Yeah, I didn't
and
see-
it outlines the results.
Okay, apologize.
Dr. Nunez.
So I know there's a season for everything, is there gonna be a similar review for the RVT?
There's going to be a similar presentation, yeah, but it won't be, not like this, but
Yeah.
it'll be more in depth in explaining the OA process and what happened particularly with the CRVT.
Okay.
We will be doing that upon the, I have to finish finalizing what our schedule will be with that, but
Okay.
yes, we will be presenting.
Dr. Nolan.
I'm assuming that maintaining the VLE would require the same amount of rigor and time and commitment, and yet we might be reducing the number of people taking it down to probably a handful, I'm guessing, if it's reciprocity. I think that's something we ought to probably consider too, the onerous of continuing to maintain a test that's for a very small handful of people.
That was a good point.
Any other comments? Any comments from the public?
Good afternoon. Tracy Montez with the Department of Consumer Affairs Division of Programs and Policy Review. OPS is one of my units. I just wanted to commend the board on doing this study because, as you know, the Little Hoover Commission is looking very closely at removing barriers to licensure, and so you should be very pleased to have this in your pocket as having conducted this. And obviously, there are a number of variables that you need to continue to explore in terms of the ultimate decision that you made, but you have in fact taken those those steps to look at barriers, or I should say the minimum requirements and whether or not they may now be a barrier to licensure. So thank you for doing that.
Thank you, Tracy, good point.
Any other comments from the public?
Thank you.
Thank you.
Thank you, great job.
Appreciate it. Thank you.
Okay, we're going to change the agenda somewhat here due to time. We're going to move number 9 to our next meeting, telemedicine. And so I'm going on to my board chair report, and it will be short because I've only been president for what, how many hours now?
Waterhouse Administration.
That was a term used yesterday, that's what that was referring to. Dr. Sullivan has agreed to continue as the board's representative on the MDC. Thank you, Dr. Sullivan. And of course, Jennifer Laredo will continue doing her great job as the RBT representative on the MDC. Dr. Nunez will chair the next task force meeting February 2nd. That's regarding animal physical rehabilitation. That will be the next and last meeting of the task force. On November 16th, I attended the board member orientation training. And as it turned out, most of the attendees were reappointments. So it really was, I was dreading it because I thought, okay, I've already done this once. I've been on the board for 4 years. Why do I have to do this again? But it really was very interesting because most of the attendants were reappointments. And so it was a different discussion. It was a lot of discussion on the proper role of board members. And one of the things that we were given was the strategic goals of the Department of Consumer Affairs. And I will just quickly go through them. One was, number 1, enforcement. Prevent, reduce, or eliminate unlicensed activity and harmful conduct by licensed professionals that pose a threat to the health, safety, and welfare of Californians. So personally, I love seeing that the number 1 goal of the Department of Consumer Affairs is to eliminate unlicensed activity. Number 2, licensing. Assure that all applicants and licensees are qualified to provide professional services and are able to expeditiously enter California's workforce. Number 3, legislation and policy. Ensure that statutes, regulations, policies, and procedures strengthen and support DCA's mandate and mission. Number 4, communication. Provide relevant, timely, and accurate information to internal and external stakeholders. Number 5, administration. Enhance organizational effectiveness and efficiency. Improve the quality of customer service in all DCA programs. And technology. Leverage and support technologies to better serve clients and stakeholders. And the last part of my board chair report is to remind all the board members that in each odd-numbered year, we all have to do the online ethics course and sexual harassment prevention training. And so I'm sure we'll all be getting notices about that. And then every 4 years, we have to do the online driver's training. So that is my report. And then number 12, Jennifer Laredo has the RBT report. Oh, sorry. Any questions or comments? Any questions or comments from the public?
Okay, my report is also short and sweet because I've only been in this position for 2 years. And unlike Dr. Klingborg, I am not an overachiever with printed, pretty red font notes, but I'll do my best. Multicolored. It makes me feel bad about myself. The first thing I have is carried over from the last report is we still have the issue of the retroactive fingerprinting with some of the RBTs prior to 2000, so we're hoping Breeze would catch that. Another thing that's still kind of currently we're working on is possible new eligibility categories. So we have the DBM graduates that we had discussed already. There's still the possibility of some sort of animal science major bachelor's degrees that was removed. It's still a possibility if we wanted to open it up for discussion. The one thing I have that I will admit I will admit my ignorance in this. It was questioned last time if we had a representative on the Committee on Veterinary Technician Education Activities. That's an AVMA committee. Dr. Sullivan had mentioned that it's an AVMA committee. It's difficult to get someone on it. I know so many wonderful RVTs, I thought it would be easy to find somebody. The people that we've identified who were very well qualified just did not have the time to take off. Most RVTs are not self-employed and they work and they can't just take off time arbitrarily when they feel like it. The ones who were willing just didn't qualify. They were not graduates of an AVMA approved school, they were not active members of NAVTA. So that's been more difficult than I had anticipated. So unfortunately, we did not at this time identify anybody. The associations, if you guys know of anyone who's very well qualified, graduate of an AVMA approved program, active member of NAVTA, those would be good candidates to suggest for that. And last thing on my list is my immune system is being assaulted sitting at this table, but we're gonna keep on going. Judy.
Well, there's, so Erica from State Humane is here and Nancy, maybe they can put that on their Facebook page. Do you have, and are those the exact qualifications for the RVT that you're looking for?
So she can talk to Erica.
Or maybe, yeah, give exact details.
Dr. Nunez.
I missed really quickly what you said. You said after this discussion about DVM graduates sitting for the RVT exam, you also said the possibility of
Animal science major bachelor's degrees. That was an eligibility category in the past and it was eliminated just because they were science. It could be a biology degree. It didn't necessarily have to be animal science.
so that would fulfill the requirement of going to an RVT program? Or
I would assume it would take more research, but yes,
okay.
that's all I have.
Any comments from the public? Okay, going on to agenda item number 13. The discuss implementation issues regarding the VA-CSP. I'm still getting used to all that acronym. Ethan is to present this.
Okay, so as you know, the VA-CSP program officially rolled out on October 1st, 2016. As we mentioned at the October board meeting, there are some wrinkles we're encountering with how folks qualify and whether they are required to hold a VA-CSP. The memo kind of outlines some of the requirements in rule. We do have several issues in front of us where we're seeking guidance from the board on specific scenarios where we question where a VA-CSP would land properly, as far as folks that would be required to, for example, a veterinary assistant, euthanasia technician in an animal control shelter are able to provide euthanasia with proper training. Are those the kind of folks that we want to see get a VA-CSP? And there are several other questions along those lines that we're seeking guidance from the board.
So just to piggyback on what Ethan is referring to here on page 2 of the memo that Ethan prepared for you, there are a list of bullets here who in fact should be applying to get a VA-CSP license. We talked about euthanasia technicians, shelter staff, other veterinary support staff who may come in contact with controlled substances. So we go back to the intent of the law. The intent of the legislation was to try and prevent diversion of drugs. And so anyone who has direct access to and administer controlled substances should be permitted. Now, where you have to kind of draw that line of demarcation is we as consumers get controlled substances prescribed to us for our animals. We don't have to get a permit to administer those substances to our animals. So the same thing would probably be true, right, of a boarding facility where you're boarding your pet, you leave your, what's the phenobarbital there, that's going to be administered to that pet throughout their stay. We're not expecting boarding staff to get that they're essentially carrying out what their owner would otherwise be doing, but they're caring for the pet. So it's a kind of a boarding type service that's provided.
There was a question about students from RBT programs. If they're handling controlled substances as students and administering those drugs to the animals, would they be required to be permitted? Well, no, because they're under the oversight of the school, and there should be should be provided direct supervision by a faculty member of that school. So I don't think it was intended to cover students within a university training program or an RBT training program. I do think that those who are handling controlled substances and independently administering those controlled substances, that being euthanasia technicians and shelter medicine staff, were intended to be covered under this umbrella of a veterinary assistant controlled substance permit, because they do in fact have direct access and administer these drugs, and therefore they should have to go through the same process for getting background check and having the permit to ensure that there's been no criminal history, felony, in relationship to some sort of either drug conviction or previous diversion.
And of course, one of the other issues we encounter is the regulation specifies this activity happening at a premises where veterinary medicine is practiced. So a shelter may not have a premises permit.
But so long as they are, if you're administering drugs,
Mhm.
veterinary drugs, to a patient for a medical necessity, you're practicing veterinary medicine. So the idea of the animal hospital setting, which is
Right.
something that's troubled everyone by definition. First of all, most shelters that are practicing veterinary medicine have a premises
Mhm.
permit that we're aware of. Those that don't have one, that are practicing veterinary medicine, are supposed to have one. So regardless, this personnel should fall under the veterinary assistant controlled substances permit, in that if they are practicing veterinary medicine in that setting, this should be applicable to that personnel.
You didn't address the last bullet about receptionists, and I think it was our intent when we wrote this not to include the receptionists.
Dr. Newton, yes.
I went down basically these 4 points like you just did, and the first 3 I said no. A veterinary euthanasia technicians, shelter staff, and boarding facility. I did take a pause though at veterinary staff, because in my hospital, when we do fill prescription for controlled substances, prescription is filled, but the prescription is actually placed inside our locked box until the client picks it up. And when the client does come to pick it up, it's either the RVT or the VS or the permit holder that actually takes it out of the box and hands it to the client. And there are plenty of prescriptions in that lock box that are prescribed, and they're actually paid for, they're just waiting to be picked up. So there's a huge potential for those to get, and I try to keep the intention of the law, and that was getting any of these drugs diverted anyplace else. So I'm not saying that the receptionist should hold a license, but it did give me some pause. That's a potential where drugs could slip away. And that might be an issue that the hospital inspectors could tell the hospitals, that these drugs do need to be locked up and until they're in the client's hands. Could be an opportunity for hospital inspectors to cover that.
See, I looked at the first 2 and said yes. Judy?
Okay, well, I definitely feel shelter staff that have access to the drugs have to have the VA CSP as well. I mean, there's so much diversion of drugs and ketamine and everything that's in a shelter is the same that's at a vet clinic. They hold a DEA license, so to me it's all the same. You know, my vet hospital, they have the
Yeah, I don't think we need to go into.
well,
Yeah.
but to his point about the receptionist, I mean, there's the locked up stuff and then there's the stuff waiting for the client. But I mean, that can be diverted just as easily. So I think that creates a big loophole that we say the receptionist and that these drugs can just be sitting, hanging out.
So I think before this law actually came into, point where it is now. I mean, we discussed access for like about a year, but that's why we were trying to come down with this definition of access. Dr. Nolan, did you have? Jeff?
I'm actually in disagreement that the veterinary assistants, AKA the euthanasia technicians, need the permit for the reason that, I know Christy's not here, but according to the law, the euthanasia technicians are veterinary assistants, but in the shelter world, they're not. They're literally the kennel cleaners who become certified as euthanasia technicians. The only controlled substances they handle is sodium pentobarbital. If they want a sedative, they have to come to the veterinary staff to get it. And because of compassion fatigue, we have to have a large group that does this procedure. So we take the people who are not the veterinary assistants, they're not working with the animals other than euthanizing them. So this is the only controlled substance that they handle.
But it still can be abused. I know cases where it has been abused. They can take euthanasia solution and dilute it out.
Yikes.
Yeah.
So Madam President, member,
Yes, go
sorry.
ahead. No, go ahead.
I apologize. I read the agenda. When I read this, I presumed that further discussion guidance by the board sort of was the royal board, like me, like staff. So what I would respectfully suggest is, so when we look at a statute, and we try to figure out what a statute means, acted by the legislature, we first try to ascertain the intent to effectuate the purpose. The way we find the intent is we look to the words themselves. So I'm gonna throw myself, not that I don't have to do already. I think the board should task the staff to answer these questions via legal. I'm not quite sure. It sounds like we have various competing theories about what the answers are to the 4 bullets. Respectfully, I would suggest that we get some sort of legal guidance on this, i.e. me, and go from there, because to interpret a regulation, to construct a regulation, you do essentially the same thing. You look at the intent. You look at the intent of the promulgating agency, would be the board. So this would be going through the rulemaking file. This would be looking through the final statement of reasons. This would be looking through every comment, figure out where the board is going. And I think if we do that, we can at least get a running start on answering these questions.
Okay, can I have a motion then to direct staff to answer these questions? Second. Any other discussion? Dr. Sullivan.
Well, I would say that being involved in this process, bullet number 4 was discussed at great length, and I'm sure is documented in the minutes that should not be up in the air at all.
I will certainly review, if the board is so tasked, I will certainly review all available records and literature and everything on this subject.
Any comments from the public?
Nancy Ehrlich-Carpta. I was on the task force that worked on writing this legislation, and it was clearly the intent of that task force to exempt receptionists from having a VICSP. It was intended to, particularly to prevent people having access to the central supply where there's a large number of controlled drugs, not individual pill vials that might have 10 or 20 pills in them.
Thank you. Yes.
Hi, Erica Hughes, State Humane Association of California. And I just, 2 things. One, under the first one, the first bullet point with respect to shelter staff, non-RVT, non-veterinarian shelter staff who are authorized to administer sodium pentobarbital. They're given authorization under statute, under Business and Professions Code Section 4827, which is the section dealing with the practice exemption. So they're given authority to do that by virtue of being exempted from the Practice Act. So I would just ask, when you're analyzing this, to take into account the situation in which you have a shelter without a premises permit, but there is sodium pentobarbital obtained by an RVT with a limited DEA license under the authority granted the RVT under 4840, I believe. Is that right? Under, sorry, 4840C, which says that a registered veterinary technician can apply for registration from the DEA for sodium pentobarbital. So that's the, we're all still confused in the sheltering world about whether or not those people are required to get a VACSP, and how does that work if it's tied to a manager licensee?
And I certainly appreciate the nuances that you put together. It may be that my conclusions, when they bubble up to the board through staff, may be that, you know, another regulatory endeavor is necessary to clarify these questions. And then in the interim, the board can do this. So I appreciate that. Thank you very much. Like I said, just kind of rambling on for a second. I know time is short. So whenever you construct a statute, you look to the words themselves, do the same thing for a regulation. And then if there's some ambiguity, then you go through this laundry list of what's the ill that's trying to be cured, what are the circumstances sort of surrounding it, what are the contemporaneous analysis that go along with that. So all that's going to bubble into that, along with the other statutory and regulatory constructions, as you mentioned, 4840C and so on.
Okay,
I'll be looked at.
Thank you so much. And then the second thing is, I would like to make a request that that the board consider waiving the application and license fee for the VACSPs granted to shelter staff that work either in a public animal shelter, a city or a county animal shelter, or in a private animal shelter like an SPCA or Humane Society that contracts with a city or county for the care of stray and abandoned animals. And there's a precedent for that with the premises permit fee. It's waived for public animal control agencies. Finally, that's because a lot of, I've heard from a lot of our members throughout the state that they're concerned about the additional cost of applying for the permit. Thank you.
Elaine Moon Carvta. I also work in a municipal shelter, and I can't stress the need enough to have this type of program in place for the people who do come in contact. Even though these people may be called animal control officers, they have not all gone through training. And some of them do have suspect backgrounds that are not thoroughly checked out. So for public health and safety, it would be really good to have these guys fingerprinted and checked out first. And then I agree with my colleague's recommendation to please waive that fee for the municipal agencies, because it is, when you have 20 ACOs, animal control officers on staff, it is a burden to the facility who has a very low importance rating to the municipality as to where the funds go from the general fund. So it would place an undue burden and prevent access to care. So that's,
Thank you. Call for the vote. His motion.
I said I asked for the motion, you said so moved.
Yes.
Refer to
staff.
I just want clarification, staff,
they're asking.
council can do a lot, and he's, you know, Herculean, or however you want to say that I can't say this afternoon, Herculean, efforts in doing all of these things. The waiver issue that Ms. Hughes brought forward is not something council is going to be able to answer. That is at the discretion of the Veterinary Medical Board as to whether or not they. Okay. Okay, I just want to make sure that we take them up separately.
I respectfully, on this, leave that alone. I think my advice on the second one would be to, when we get down to future agenda items, put that on the future agenda items less than and the board can have a full-on discussion about whether or not, you know, what's the anticipated revenue loss, or whether it's warranted and everything like that. I think the motion, as I understand the motion was refer this issue to council and then have him prepare some advice for staff and then ultimately be brought back to the board.
Yes.
To clarify. Call for the vote?
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Go back to my page. Dr.
Yes.
Nunez?
Yes.
Dr. Nolan?
Yes.
Jennifer Laredo?
Yes.
Kathy Bowler?
Yes.
Judy Mancuso?
Yes.
Motion carries.
Would you mind repeating the motion?
The motion was to defer the answers to these questions that were posed in the memo to legal counsel and staff. Counsel will advise staff, staff will advise the board.
Agenda item number 14, review revenue and expenditure reports and discuss need for a fee increase of initial license and renewal fees, potential action. So this will be Ethan and is Matt here?
Yeah, Mr. Nishimini. Yeah. So you have a couple documents in front of you. You have a memo written by myself, and then another document prepared by our budget staff that was emailed to the board. And you have a hard copy that has the memo. Yeah, plus.
Yeah, show us.
Plus a fund condition status. In my memo, I outlined a determination we've made as staff that there is an ongoing structural imbalance with the board's fund. That is to say that our expenditures are exceeding our revenue. I've also outlined some of the issues that have led to that. Among them, we've increased our staffing. There's been some inter and intra-departmental increases in expenditures and Attorney General expenses.
I think Ethan, they're trying to find that memo. It's in your board binder under agenda item, or Ethan emailed it to you.
Yeah, mine is under 14, then the
Yeah,
additional one was
distributed yesterday.
distributed and also emailed.
Yeah.
And what was,
It says fee analysis recommendation at the top.
that's what, I wanted to make sure that's what it was.
We've also, my memo also included a couple colorful graphs illustrating what I just said about the structural imbalance and how our costs have increased going back from 2012-13 to 2015-16. I'll take any questions you have about that. Regarding the fund condition status that Matt will be speaking to, the fund condition status is just a document to show our year-over-year revenue and expenditures. And what we're looking at is the structural imbalance at the bottom of those particular spreadsheets that reflect a deficit in our revenue versus expenditures. Did I go too fast?
Okay, there's a lot going on here, so I'm gonna try and pare this down quickly, and then I would like to ask Matt to answer some specific questions. So we're looking at conducting a fee audit, right, across the board by a third-party vendor. And that contract is currently being vetted, and it's gone out for bid, and I think we just recently, as of the last couple of days, received a response. So today you will not see a very specific recommendation for an increase in fees by X number of dollars for veterinarians, RVTs, premises, and VACSPs, because we don't know what that dollar amount is yet. What we do know is based on the fund conditions that are in your packet, and those will outline, the very first one is, here's where we are today, and if you look at where we are today by budget year +2, which is 1920, we're in a deficit. And that's if we don't get any additional revenue. However, that does include the anticipated VACSP revenue, right, from the new category. We don't really know exactly what that's going to look like because it's only been, as Ethan mentioned, it's only been ongoing for the last couple of months.
So that's kind of an anomaly. We can't base our future structural balance on an unknown. If you turn to the next fund condition, you'll see at the top it says governor's budget, no VACSP revenue. That means this is taking out that anomaly, that unknown. And in doing so, we're almost at a deficit in 18-19, but we're even at an even greater deficit in 19-20. And Ethan, I don't know if you mentioned the statutory requirement that you stay between 3 and 10 months reserve.
Yeah, I did not mention it, but yeah, it was in my memo that we have to, we have a sweet spot
Yes.
in our budget.
So in the statute.
And also the EO goes to jail, right?
Right, and then the EO goes to jail, there's that too. That's small detail, you know, but Matt's gonna keep me out of jail. So, not all boards have a statutory requirement to keep their savings account between a certain number, but the Veterinary Medical Board does. And months in reserve is, if you were thinking about your own household budget, you would have to have a savings account of at least 3 months of your household budget and not more than 10 months, that's what that means. So, even in these scenarios where we have VACSP revenue, we're not meeting our statutory requirement for the reserve, right? Because we're not at least 3 months in reserve. So now moving forward, the next fund condition said, hey, if we were just to say, we need a lot of money and we need a lot of money now, let's move everything to the statutory max, right? The statute says that we can't exceed $500 for renewal and then $300 for application fees. If we were to do that, we would definitely meet our statutory requirement of having 3 months, and the EO would get a new pair of shoes.
And we'd have hospital inspector uniforms.
Right, and we'd have inspector uniforms. But in budget year plus 2, 19-20, we would have exceeded that statutory max because we would be on our 10 months, right? So that's not the recommended method at this point because it doesn't keep us in that 3 to 10 months. So then the very last analysis, if you will, that Matt prepared, Matt picked a fee below the statutory max just to see where that would get us. And it looks like based on that magic number that we don't know what it is because it's top secret, based on that magic number, it gets us between that 3 and 10 month reserve in terms of future fiscal years. However, we don't have a recommendation for you today as to what that number is because we really want to see what comes out of this third-party fee audit before we just throw out an arbitrary number. We want this to make sense based on program needs, anticipated costs in the next 2 years, what we pay DCA to keep the lights on and everything functioning, our client services. That all needs to be captured in that audit before we can make a recommendation about a specific fee. What we want you to be aware of, the reason you're seeing this today, is if we want you to know as a board, you will see a fee increase proposal, and hopefully by April. Because if we don't do a fee increase, we're gonna have to stop providing some services that we currently provide. And we can't do that, because that would be stop doing enforcement, stop doing hospital inspections, stop administering exams. So we really need to look at where is that prudent middle ground for, a conservative increase in revenue that we can continue to function at the level we're functioning at today, and also allowing for some of that inflation that we see over the few years following that.
And the last increase was in 2012? Dr. Nolan.
What's the cost of the external audit?
So in your memo, I think Ethan outlined it's anywhere between $25,000 and $50,000. Sorry, because I let Ethan answer that.
That's okay.
Sorry, Ethan, go ahead.
Yeah, that's correct. I've seen contracts anywhere from 25 to 50. And so we're soliciting for bids right now. We are getting some folks responding to us currently. The timeline for the audit itself is several months. So we hope to have something in April, but we'll see when that contract can get started.
And is that reflected in the budget, that expenditure somewhere?
The contract itself, no. It's not a known cost yet.
Can I ask?
Kathy.
Excuse me. And in the usual volume pricing situation, I'm not sure it even applies, but are there other boards looking at this as well? And can we combine with another board for a fee audit? and maybe reduce the individual price, or does it make no difference because every board and every license is different?
It's very specific.
Yeah.
Good afternoon. I'm Matt Nishamini from the DCA Budget Office. And so to answer your question, no, it's all a la carte. Each board is very unique, and your board has very specific license fees, which are very different from the medical board or the pharmacy board, which is another good reason to have a fee analysis done, to see not just the fee levels, but the fee structure, and to see how you compare to other like boards, like licenses within DCA.
May I ask another question? Because I totally agree with the fee audit. If we're in all of these scenarios, there's no VA CSP revenue or expenditures included, which probably is conservative right now. But assuming, but there's a question out there. We've had 2,000 or so applications. I know the application process is taking a little bit longer to get them finalized. But once that is up and running in maybe 1920, is that going to make? Will we exceed in our revenue the expenditures that it's costing to process those?
So I think Ms. Del Magnaio's characterization of the 4 fund condition statements was very accurate. It's really just to try to tell you a story, to prompt you, to show you that you do have options. The first one is from the governor's budget that was released on January 10th. So this is your budget. So this does include projected VA CSP revenues and expenditures as we have them budgeted now. The second, third, and fourth fund condition statements, we've pulled those numbers out because we think at this time they're unreliable.
One more question. The other maybe unknown is the VLE and what implications are involved in changing that, eliminating it, et cetera. So will the external audit have the ability to analyze that?
Well, so I mean, certainly we're going to look at all of our revenues and how they impact the expenses we incur by program area. So that would be one of the revenue areas.
So we know that our current fees are not going to cut it, and we know how high they can be. And based on this one chart that says, what if we set them to the max? Mm-hmm. We find that that's too much. But in order to keep in that 3-month requirement, would it be a safe assumption to think along the lines that fees are going to go up by about 25%?
So this is why this is such a good time for the board to be considering these options, because the fund is healthy until 1920, so you have some time. If you go straight through the regulatory process, we're looking at about 18 months. So we're a year and a half off. If you go through the statutory process and you have to increase your statutory caps, we're looking at 2 years. So it's going to increase the timeline. We're going to have to get those fees into a bill and approved through the legislature.
And even if we go below budget 1 year, she still goes to jail.
We're not going to let that happen.
And the other question I had, if we do have oranges, if we do have a fee increase, is it going to be across the board, or is there potential for it to be raised a little bit more on some categories?
I think that's what the fee analysis will show. It will show, it shows, as Ethan mentioned, it'll show not only what the revenue is, but where the costs of that fee are going to. So to the individual units, to your licensing unit, to the enforcement unit, and to the admin, it's going to show the cost.
No, I mean for whoever we admitted licenses.
Right, so.
Because I hate to stick it to the RBTs even more.
I think that's at the discretion of the board.
And as I'd like to point out that these companies that they're looking at have been, they've done work for DCA before, and they're used to doing licensing fee analysis.
So they will also give us their recommendations on that?
So
yes.
the fee analysis from this third-party vendor and we're using vendors that other boards have used in the past, right? Those vendors are bidding on this particular contract. Their goal is to analyze what revenue's coming in and what are our expenditures by program. And then they will provide recommendations for how much additional revenue we need to be supporting our budget and have a reserve between 3 and 10 months, because that's our statutory mandate. In terms of equal taxation for the license types that we serve and that we license, I don't think with the type of scenario that we have in these individual boards, it works out that way. So if you were doing this in a traditional private business, you may be able to say, these are your costs for this particular program area, so those costs should be supported by the clients that utilize that service. Because you have a disparity in the number of people you license by license type, right? So there's 3 times the number of veterinarians that there are RVTs. You're obviously going to bring in more revenue from the veterinarians than you are the RVTs, and then more revenue from the RVTs than you are the veterinary assistants. So if you were to try to attach as I said, equal taxation, RVTs would be paying probably 2 to 3 times as much as they're paying now, just because they're a smaller population. So you can't look at it as, they are also receiving the same services as the veterinarians. They have the licensing staff serves the veterinarians and the RVTs. The enforcement staff responds to complaints and disciplinary actions against both. And there's the exam program that does exams for both veterinarians. So if you were trying to parse that out and equally charge those populations, there would be a higher rate for the RVTs because they're a smaller population. So you have to look at it by both the money that is being devoted to that license type or the services, and then also kind of and I don't know how you would capture this, but essentially the professionals' return on investment, if you will, what their likelihood is to make money and to.
So as you have explained it,
Not so
difficult
openly.
question. Does the company also give us recommendations on that, or is that completely our job?
In your experience, Matt, have
Yes.
you seen them recommend a certain fee for a certain
A
license?
certain fee level. And in many cases, when the fee level was presented to the Board or Bureau, there was pushback for the reasons you're mentioning, that might not be acceptable to the licensees. And so there is some back and forth.
But it will be provided.
It will be, yes.
Okay.
Yep.
Does, just a question, does the fee analysis take into account the median salaries of these professions?
Right.
Dr. Nolan?
Matt, does the DCA do any internal auditing to kind of compare with what the external group comes up with, or do they do a spot checking, or what? How does that work?
We'll certainly be part of the review process, but it really is best left to the professionals, the third-party professionals for something like this.
It just looks like some of these are, no matter how close you get, you have to just guess at some point. And so sometimes the most educated guess comes internally, or at least with some help from maybe even our VMP.
Any other comments? Any questions from the public or comments from the public? So again, this is for informational use.
I just would like to point out that the breeze expense grows exponentially by year. Ethan.
And speaking of that,
My baby.
Not your fault, I know.
Wasn't my baby.
agenda number 15, the administrative budget, so.
Thank you.
Thank you, Matt.
Thank you.
Thank you, Matt. So Ethan is up on this also.
You're right. So again, these are documents that are emailed to you as I got the most current documents when they were emailed. So as opposed to the fund condition status, looked at the yearly. This is my regular monthly report, FM5. So I provided 2 separate expenditure reports. The first expenditure report is a snapshot of where we're at in FM2, okay? And some of the expenditures, namely the ones that are in the highlighted lines, are projected expenditures based on what we know those expenditures will come in at based on past experience. The reason that's important is because we're at the end of the day, we're looking at the bottom line, the surplus deficit at the bottom right-hand side of your worksheet. So it's important to us to make sure we're tracking that. As we did discuss last fiscal year, our final number was very tight. It was like I think 1/3% was left remaining in our budget. So this first spreadsheet did project out what we're looking at in the current situation if we continue expanding at the rate that we're expending at for the entire year. Okay, so that's that first worksheet. The second worksheet, because we do have a very substantial Attorney General Office of Administrative Hearings costs, we are asking for a temporary augmentation to those line items. So the second worksheet reflects that, and that in turn affects the bottom line, again, bottom right-hand corner of your spreadsheet. So I just wanted to illustrate that containing those costs as in that we're getting an additional appropriation for those particular line items will get us from the negative to the positive at the end of the year for all things are equal.
So this was as of November, and so is there any VA CSP revenue in here?
No, these are the expenditures as compared to our appropriation.
Okay.
We do get revenue reports, and as Kathy mentioned, the applications are coming in, so we're actualizing revenue.
Judy?
So what does OAH augmentation mean?
So our appropriation is set in the budget, okay, and that's an assumption based on what we spent in the past, okay, and so the last couple fiscal years, those expenses have come in higher for various reasons. We're doing more work. Their expenses have come in higher as well. They're increasing their cost to us. So what we intend to do is go above and beyond our budgeted appropriation for those two line items. So whereas our appropriation was $460,000 for the AG specifically, we know we're going to spend probably about $640 or $620, $640 this year. So our ask to Department of Finance is to increase that this year. In addition to that, we have a BCP that will be approved the following fiscal year that will increase that appropriation to a more realistic level year over year to match our expenses. Does that answer your question?
What? No, because that's almost $200,000. I didn't know that we can just ask for more money.
There's a
That's what
well, so in the budget bill, there's an ability for each board for certain line items to increase their appropriation, and in our case, we're in pretty dire circumstances. Right. We're going to be negative. So in lieu of
Anne Marie will be in jail by
June. In lieu of stopping the expenditures to the AG, we're using our tools in our toolbox to temporarily increase the appropriation.
I'm glad we can do that.
So is it just temporary? Yeah,
I didn't know it was available
until a one-time thing, or can
every year we have that ability.
So there was a statutory change, and it's been probably 4 or 5 years now that statute went into effect that gives the board, and it's not really authority, it gives us some purview to request money, but it's only specifically for enforcement. We can't do it for other line items. So we can augment our AG budget and our OAH budget because there was this statutory clause in the Budget Act that gave us the authority to get money from our fund. We have to show that we are overexpending that line item, and we have to show a history of overexpending that line item. And then there's a request that the Budget Office assists the board with submitting to the Department of Finance. And then we request additional funding for the purposes of enforcement only. So in any other situation, we would have to we'd have to go through the budget change proposal process, which is
we have done,
arduous.
Yeah.
And we do that every year for other reasons. But for the purposes of enforcement, there is this permissible path to get money from your fund.
I'm Diane Sokoloff, I'm from the AG's office. So I had a question, and it's not surprising at all to me that your expenses are increasing, and we all in my shop anticipated it because in large amount because of the increased staff, because of all the new additional staff. The veterinary in your department, you have the ability now to do more enforcement. And because of more enforcement, there's going to be more cases, which makes complete sense to me. I'm just wondering if at some point, given the fact that now you are going to be generating more of these types of cases rather than have to get into this situation each year, are you eventually going to be increasing or is there going to be an increase to the amount of money that you have to spend?
Yeah, and so to my earlier comment, we have, about this time last year, we started the budget change proposal process to ask for an increase in our appropriation, and that it was a DCA-wide effort because a lot of other boards are seeing this kind of scenario play out. And yes, that has been approved to increase our appropriation for those two line items. So we will permanently see it.
You're right, so
not
that
this
makes
fiscal
sense.
year, but it's going to take effect next fiscal year.
Thank you.
Yep.
Dr. Nolan?
And has that increase in those two items in the budget been reflected in your scenarios that you gave us?
If we're talking about the fund conditions statement, no, because it was not known at that time. So it is definitely one of those factors where it's very fluid. So now that we know that, yeah, those expenditures that would normally be drawing down our savings account. So it's something we need to think about. Mm-hmm.
Any other comments? Any comments from the public? Shall we move on to enforcement?
That's
Or at least you can just say
Can I go now?
licensing. How about if we do that?
Okay, admin licensing report. The report is provided for your review. I did want to, as always, touch on a few items. You'll note that I actually have some figures for our VACSP apps received. That number in there, 977 apps received on the first page at the top right. A little bit dated. We have about 2,000 applications received at this point. We've issued somewhere close to 400 permits from that. Below that, you'll see our exam results. Moving on to exam development. You had your presentation today that talked about the VLE. We did talk about occupational analyses yesterday and a little bit today. There is an ongoing RVT occupational analysis. The OPES folks are pulling those results from the survey together. That should be hitting our desk anytime now. But we will withhold a report to the board on the OA until we've had a chance to compare our California OA with the national occupation analysis, and we're anticipating July. We should have a final report for your review. As part of this VLE exercise we went through, we also created 2 new exam forms that did cost us money, but it did update the exam that was somewhat dated. So we are rolling out a completely new VLE exam that will follow the normal process. Every 6 months you release a new exam form to keep it fresh and keep people current on the laws. And that's pretty much it from my report. If you have any questions. Yes.
What's the turnaround for the VACSP right now? As far as you said, you have 2,000 in, you've got about 400 issued. How long is it taking you?
Yeah, and unfortunately, because we have such an influx, and we know we did get staff for this purpose, but 2,000 applications in 3 months is a lot. So we're looking at 6 to 8 weeks to get a permit issued. It does take time.
And so I think, if I remember right, then the projected estimate in the
Yeah.
past had been like 10,000 or so. How do these projections, for after just a few months, how
Well,
compare to?
I'd like to think it's pretty favorable. Although I'd like to see it 6 to 8 months from now and see where we're at. One thing I do want to mention: 93% of those applications are coming in online through Breeze. So, yay Breeze!
Is it easier when it comes in through Breeze?
Absolutely. If not just for the paying the fees, we don't have to cashier in-house. They can do it by credit card, and they just hit our front door. We start processing. A lot of times you have to get a couple extra documents, but that's okay. It's normal.
And I'm sorry, what is the fee? I've forgotten that.
It's $100 total, $50 application fee, $50 permit fee for the first biennial license, which is a 13 to 24 month first license.
Any other comments? Any comments from the public?
Lynn Moon Carvta. We just want to express our disappointment to see that the pass rate for the CVTLE has gone down from 94% to about 62%. And we feel that's because there was incorrect information posted on the website to the candidates that was not updated in a timely manner. And I also have printed materials that were also incorrect sent out to the candidates that had the incorrect study information on. So while I do agree with the board that it is not your job to tell us how to prepare candidates, I do submit respectfully that when you do post information, that it be correct and current. Because this is like a week's salary for somebody to pay all these fees to get the exam. So this is really important, and I would like you guys to take it seriously. Excuse me.
I think we all take it seriously. But Ethan, do you have anything to?
Well, echoing what I've said before, is that so the candidates get the current candidate information bulletin at the time of their eligibility. On the first page of that candidate information bulletin, it suggests that the candidate check the website for the most current version in case it has been updated. So we do our due diligence to make sure they have the most current information. Because the CIB does change from time to time based on exam forms being rewritten.
I can tell you that that information is not in the bulletin submitted to the candidates. And I do have one here that was postmarked November 4th, and it does not have the current information, nor does it tell the candidate to seek out that information on the website.
We can take a look at that and make sure that it is on there.
And I went through that all night. I still submit that the information in here should be accurate. Because
But is it on that pamphlet or not?
it actually, I see it here, right here. I missed it combing through it all last night, so I apologize for that.
That's okay, we're all guilty of it. Thank you.
Any other comments from the public? Now, should we go to enforcement?
The attachment that I just handed out actually goes with the complaint investigation section, and I apologize that it wasn't attached. I think there was a miscommunication there. In November, we held an expert witness roundtable
Dr. Pollard and Dr. Grant reported yesterday on kind of the content and the outcome of that meeting. I think it proved to be very valuable for everyone that was involved. I know I learned a lot from it. I got a lot of positive feedback from it. We're looking forward to putting into play some of the suggestions and recommendations that were made from that meeting. We're looking at holding our next expert witness training. That'll be here in Northern California. We haven't yet determined a date, but hopefully we'll be able to do that soon. In complaint investigation, with the implementation of the VACSP, we kind of have yet to see what type of workload that's going to generate for enforcement. As of roughly the middle of December, there were approximately at about the same time that Ethan's reporting, so when he had 977 applications received, roughly 50 of those applications required a second review because they had some sort of arrest or conviction that came back from that. Those may or may not come to enforcement because of the different structure with the VACSP regulations, in that an individual who is arrested or convicted on a state or federal felony regarding a controlled substance is not eligible and doesn't meet the requirements for a VACSP. So that's not a situation where it's a denial where it would come to enforcement if they were to appeal, but it's simply that they don't qualify to apply. In December, Sean Gerson, and this is the information that I passed out to you, was actually taken into custody by federal authorities. I include this because it's particularly gratifying for enforcement. This is an individual that I know has been on the board's radar for a long, long time. We've received multiple complaints over the years regarding Mr. Gerson's business activities. And I know that past complaints, in conjunction with the Division of Investigation, we've substantiated his illegal activities. We've referred it to the District Attorney's Office, and we've been declined in our request to file criminal charges because they felt like there was no consumer harm. I disagree, obviously, but I think this just goes to show that he's on the radar of a lot of people, and so hopefully this will be
Did you attend the
come to a
takedown?
head. I'm sorry?
Did you attend the takedown?
I didn't. I wanted to, I didn't. He's actually scheduled to be arraigned tomorrow, so we'll see what happens there. But the information that I passed out is what should have been included, and that is a blog post by the Division of Investigation as well as the news release by the United States Department of Justice. Very, very interesting read. In the formal discipline unit, we continue to work closely with the Office of the Attorney General to resolve disciplinary matters, monitor and mitigate costs, and see that appropriate discipline is sought. Following the October board meeting, where the board approved the legislative change that would stagger the term within which an individual could petition the board for reinstatement of a license, early termination of probation, modification. We have submitted a legislative proposal, so that is in the works. Our probation monitor program, at this point, they're monitoring approximately 100 probationers. We have seen several probationers successfully complete. We've also had a number of cases where there have been repeated acts of noncompliance, and those individuals we have sought subsequent discipline on and resulting in either an extension in the term of probation, voluntary surrender, or revocation of the license. Attached to the report is the statistical profile for the first 2 quarters of the 16-17 fiscal year. I'll save you the torture of going through those unless anyone has questions. I'm happy to answer those. The forecast for the 16-17 quarter 3, you can expect to see 2 mail votes between the January and April meetings. I know at this point in time we have approximately 7 cases awaiting in the queue that are ready, or that are almost ready. We have one petition that has been submitted that will be coming, hopefully coming before you in April. Staffing update, staffing has been a challenge in enforcement for the last quarter. But we are moving forward with recruiting to fill a vacancy, and also, as Ms. Delmanayo pointed out earlier, we are trying to get some assistance from a retired annuitant, so that should be very, very helpful.
Why has it been a challenge?
We have an analyst that left in October and went over to the medical board, and she was one of our most senior employees. A lot of history and knowledge went with her. So we're recruiting to refill her position. And then we've had another employee out on an unexpected leave.
I see all the dates to complete are all coming down, so that's very nice to see. That's great.
It's a slow process, but we're definitely headed in the right direction.
And a lot of good work.
Thank you.
Did we vote on you talked about the legislative change for reducing penalties.
Mm-hmm.
Did we vote on that last time? I thought so. And what was that? Can you refresh my memory? Was it 2 years or so?
Well, it's a staggered term, and if I remember correctly, basically it was 3 years for reinstatement, 2 years for early termination of a probation that is 3 years or longer.
Okay.
1 year for modification, and then it also provided the board with flexibility for extenuating circumstances.
Only 1 year for modification.
You voted on it at the last meeting. You did.
Can I ask,
Dr. Nolan.
Candace, I commend you on the average days to close going down. The only category where it was not was the AG category for the Attorney General cases. And can you give us an idea of what's going on there?
What happens in that situation is that number is based on the average of the cases that were closed during that quarter. So obviously our AG cases are the more egregious cases, and those are the ones that just by nature take longer to resolve. Included in that were some very, very old cases. So that kind of
Do you have a goal in mind for that category? Is there something you strive for?
The performance measure set for the board is 540 days. So that's the goal.
And what are the other, I've forgotten the other goals for
The other goals for completed investigations that do not result in disciplinary action is 365 days.
Any other comments? Any comments from the public? Shall we move on to hospital inspection? Patty's going to talk about the update with hospital inspections.
Hello. So y'all received the program update, and just a couple of things I wanted to highlight from there. Staffing issues, we're just about ready to fill the vacant position that was left by Ms. Kennedy. And our newest staff member, Miss Emily Groves, she's done a great job in the premises and inspection program, so I just wanted to commend her. In a short time, she has been able to really take the reins over from Miss Kennedy. And she's becoming our breeze expert. She's young, so it comes easier for, it sure does. Regarding minimum standards, we have had some discussions about that with Anne Marie, and I'd like to have further discussions with the consultants to update our checklist as needed. And we're making every effort out in the field to present these standards as consistently as possible. That's our goal. we've got 16 inspectors out there. Do we always meet that goal? It's a work in progress. But Dr. Grant Miller always does a great job of letting us know when it doesn't happen. So, so we do thank him for that. I mean, he does a great job in letting us know. And we do our best to, keep the inspectors updated and, just making sure everyone is on the same page. The DEA issues, Emery, I don't know if you want to bring that up, discuss that a little further.
Okay, so this is something that we can consider for a future agenda item.
Mm-hmm.
It is in Patty's report. I learned at the AABSB conference this last year that there are about 8 states that have a DEA facility license, wherein the actual animal hospital has a DEA registration, and each doctor within that facility has a subsidiary license, or they consider it a suffix, that they're listed under that facility. It's relatively new in veterinary medicine. Human medicine, this is done much more often. But it's something for California to consider. Now, in order for us to consider premises as being a facility eligible for a DEA license, we would probably have to look at the statute and determine whether or not we need to add the authority there. So the premises can hold the DEA license, and each doctor within that premises would have a separate suffix under that umbrella of that facility. What it does do, why it may be beneficial, is instead of the way things are done now, where we have one person perhaps in a hospital that has a DEA license and everybody else is dispensing drugs underneath that sponsor, if you will. If there's a problem of drug diversion or something else, you go back to the individual that holds the DEA license. Well, that individual may not have been the one responsible for the diversion of that drug. Obviously, there's several other people using that DEA number in some capacity. And I think, moreover, and it might warrant a representative from DEA to talk to the board about some of the potential pitfalls with having one person holding a DEA license and everybody else dispensing under that license, is that truly I don't think we are enforcing the rules that go along with that person that has the DEA license, sufficiently supervising everybody else that's dispensing controlled substances under that license. It's not just access to the records. It is oversight and relationship with the patient. So there's, some other things here that the federal government says they enforce that I don't think we actively enforce in the state. And just for consideration, if you are interested in having a representative from the DEA come to a board meeting and talk about this opportunity for changing statute to allow for a facility license, it's something that we can arrange.
Dr. Nunez.
I say we put this on as an item under 16A, items for future meetings.
Okay, I think that's a great idea. Dr. Sullivan.
I was under the impression that every doctor in the practice that was prescribing or dispensing had to have a DEA license. The drugs come in under one person, but our associates all have their own DEA license.
And that's the way I do it as well.
Not in all practices.
Mm-hmm.
I was just gonna reiterate to Emery, I was in that workshop at the AABSB meeting, and it was quite interesting, and it actually makes a lot of sense logistically and human nature-wise. Everyone has their own license.
It'll be cleaner.
Mm-hmm.
Yeah.
A little bit more responsible.
That's a good question, too.
And I think for shelters, what I know of that is like there's one DEA license for 5 shelters. So that would be an interesting conversation to have as well.
You can
Ride-alongs, these are ongoing. If there's any, I know there's some board members in the past that have participated and have found those very interesting. So if there are any other board members that would like to participate, just let me know, shoot me an email.
Who's done a ride-along? I have.
I was scheduled to have one, but our dates got messed up, so we're working on the rescheduling, so I'm looking forward to that soon.
It's interesting.
And we're having staff go on some ride-alongs as well.
And you can arrange in Southern California, right?
Mhm.
All right, so will you email me?
Yes.
Please? Thank you.
With regards to staffs, to the statistics, I'm happy where we're at this point, kind of the halfway mark. It's not quite reflected on the stats because those ran through the end of November, but statistically speaking, I'm happy where we're at this point, and we're on target to meet our goal for this fiscal year. And I'm especially pleased to see that compliance rate after initial inspection go up. So we're hoping to see that upward trend continue.
And what is your definition of that after initial inspection?
After initial inspection, what is the compliance rate? Are the facilities coming into compliance with all the minimum standards? So that rate had been
at the time of inspection?
After the initial inspection. So it could be about, they've got 30-ish days to come into compliance.
30 days.
That's like the approximate, yes, because sometimes we give them a little bit extra time, mail-wise, that type of thing. So it's really after the initial inspection, it may not necessarily be 30 days, but it's before we touch it in the office. So that had been about 35%, and we're seeing it move upwards. And so I think that's just a reflection of, what we're doing out in the field and bringing everyone into educating them. And so I'm happy to see that number.
Patty, wasn't this number like 18 or something? Was it really low before?
It had been running about 30 to 35.
So you go do the inspection, you find things wrong, you send them documents that say, get all this right. And then within 30 days, 40% come and comply with those actions. Are they complying 100%? 40% are complying 100%?
Right.
It would be nice to be higher.
It would be.
Give her time. Give her time.
We're moving in the right direction, so
Afternoon, yes.
we're glad about that.
As you probably know, my own hospital was inspected
Yes,
recently.
I do know.
And I'd like you to know that the hospital inspector was very professional, very friendly, very informative, and appeared to be extremely well trained, and I was very proud of you.
Oh, thank you. I know exactly when that happened. Yes, I do.
Did you pass?
She's. I believe they're still in their 30 days, so I'll let you know at the next meeting. Are there any questions, concerns?
Any comments from the public?
I just want to make one comment. Patty and her staff do a tremendous job at trying to juggle not just the inspections and assignment of inspections, but the numerous inquiries they get from managing licensees and other hospital staff, receptionists, about, they're very anxious when they are inspected, and they manage to respond to every single inquiry they get, and it's not an easy task. So thank you, Emily and Patty and your group for doing such a heroic job.
Oh, thank you.
I wasn't going to use Herculean, but now I can say it, so the medicine's wearing off. I don't know. I was still on my Sudafed high. The other thing I did want to mention is the premises task force meetings that CVMA has been holding and I've been participating in. A lot of these issues about consistency and how we're inspecting the hospitals come up during those meetings, and I want the folks in the room to know I take that information back to Patty. So when she was talking about updating the checklist, one of the more specific items that there was a request for was how to maintain their antiseptic machines and their equipment. Anesthetic. The anesthetic.
Sudafed's bad.
Medication. Ooh, wow. Sudafed should be a controlled substance. And I'm going to drive myself home tonight. So, on that note, how to keep that equipment functioning and what it takes, and there wasn't really anything that explained that in our checklist. So, we're trying to make those changes to reflect the feedback that we're getting from the CVMA task force.
Great. Yep.
That's great. Dr. Sullivan.
And there's a great article in the recent CV that Grant Miller and I think staff also did put together that is a great summary of the complaints and what we need to do to correct them. And we're definitely going to make sure our members get a good look at that. It's very well done. Grant.
The top 10? Yes. Those are the top 10.
Great job. Grant, did
Thank
you want
you.
to add anything? You can tell us how great we are. It's okay. You can find your way to the mic.
Just one.
Yes, yes.
So Grant Miller, CVMA. So just for the record, for every one time I email Patty with a complaint, there's about 20 times I email her telling her they're doing a good job. So there you go. I'm not that bad of a guy.
No, not at all.
Thank you, Dr. Miller.
Okay, thank you.
Okay, hey, we're almost done. Item number 16, agenda items and next meeting dates.
Okay.
Anne Marie.
So, I think this will be efficient if you would all like me to go through the list of next meeting agenda items that I've recorded from today, although this could be a little tricky given my last statement. We will have legislation on the next agenda because we will actually have a legislation to consider at that time. The issue of telemedicine was tabled to the next agenda. Language regarding 2027.5 veterinary graduates applying for RVT license will be on the next agenda with some input from legal counsel. We will also be following up on the VACSP program implementation questions. Council will advise staff, and we will also be sharing that information with the board. The consideration of eliminating the VLE exam via statutory change will be on the next agenda. Disciplinary guidelines after Kurt's review will be on the next agenda. The fee audit recommendations, provided we have recommendations, which I hope we will for the April meeting. And we can discuss in more detail the facility DEA license, and hopefully I'll have someone here from the DEA to provide more information about that opportunity. Any other agenda items I may have missed?
That's your meeting dates.
Okay. Meeting dates, the next meeting date is it on here? Oh, there we go. April 19th and 20th. And we are working on a contract with the Waterfront Hotel. Yes, we're a go in Oakland. I like that place. Okay. And then July 26th, 27th, either in Sacramento, Southern California, just depends on where we can get a site. And then October 19th and 20th, as I mentioned yesterday, we'll be in Fresno at the Fresno Zoo.
Yay. That's what we're working on. Don't speak before you know what you're talking about.
Anne Marie, may I ask a question about the coming items as well? Was one of those a clarification once we do a little bit more research about the Olympic needs and
I think the motion
how the
was
process works and
yeah, I think the motion at this point was I was going to work with council to write a letter back to the committee,
okay.
and then at such time that we know that that is a go, and
right.
we'll find out
The
in
committee
September.
can give us
Then the committee can give us further information about how we may need to move forward with exemptions and what have you. Yeah.
okay, thank you.
So wasn't there wording that we were supposed to have another set of wording go to legal counsel from the MDC? Did you say that? I missed it.
Yeah, that was the 2027.5 on the
Rodeo thing or
graduate students. That would
like
be
the rodeo thing or
the emergency drug.
yeah, that one.
Yeah, that one. The MDC recommended to the board to adopt that language, and you folks adopted that language.
Send it to council for some reason.
Well, there was some issue as far as the statutory requirement, consideration of a statutory change to allow RVTs to transport controlled substances. So that was the second piece, and that the MDC was going to further examine. Yeah. Unless I'm missing, is there other language that I might have missed? Any? No. Kurt doesn't take notes.
Okay.
Doesn't leave evidence behind. That's all I'm off of you.
What was the thing that we talked about? 17?
Yeah.
Okay, agenda item number 17, public comment on items not on the agenda. Is there anything from the public? I'll take a motion to recess.
I so moved.
Second?
Second.
Second, so yeah, whatever.
Can we just, yeah. Very good. We can just do that. Good. Tomorrow at 9 o'clock.
Thank you.